এ কোথায়? দেবনাথ বাবু কি চালাবে? কোর্ট কোথায়? কোর্ট অফিসে কোথায়? বলুন ওকে দিতে। হ্যাঁ, কেন দেবে না? হ্যাঁ, ইয়েস।
Yes, my lord, may I be permitted to mention on motion, my lord, pension. My lord, the petitioner, my lord, retired, my lord, in the month of, my lord, April 2025, my lord, till date, my lord, no pension payment order has been issued, my lord. Upon notice, my lord, to the respondents, my lord,
Give it to me.
Sir, may I be permitted to mention one matter, my lord? Is already in the monthly list, my lord. The primary teacher, my lord, suspended, my lord. No substitution allowance was given, my lord. I am in very bad condition, my lord. Kindly hear me out.
কত মোশন কততে আসবে? মানে তো পেনশনের দিনে পেনশন ম্যাটার, why are you mentioning?
My lord, this is
I have already divided on Monday and Tuesday the pension
Well,
matters will taken up. This matter will appear.
suspension, my lord.
Will be taken up. Don't worry.
My lord,
You go back
851, my lord. Kindly give
No,
one, my lord,
no.
some precedence, my lord.
My lord, may I be permitted a motion matter? My lord, the petitioner is
May I permit to mention one transfer matter for which an interim order has been extended till 12th of December. Your Lordship, I mentioned it last day. Your Lordship had directed me to bring a copy of the order. Your Lordship, I brought it. If Your Lordship kindly sees. Your Lordship, the order was passed by Honorable Justice Amrita Sinha, having the urgent determination of primary. The matter was scheduled to be listed on 3rd December, but Your Lordship, the matter has not appeared.
তারিখ তো আমি ট্রান্সফার কবে নিচ্ছি? আজকে? আজ তো হবে না।
If Your Lordship fixes any day as per Your Lordship's convenience before 12th of December.
10 থেকে extension of interim order রেখে দিন। 10th extension of interim under the heading extension of interim order. 10th.
Your Lordship.
My lord, may I be permitted to mention one matter? The petitioner is now 78 years of age. Money has not been paid. The payment of pensionary benefit, my lord. Now he has been facing
What
some
is the
several.
item number?
Yeah, my lord.
Item number?
Item not in list, my lord.
Which list? Monthly list?
Not in the list now. Not monthly list on and.
You have checked the monthly list?
Yes, my lord.
Huh?
I'm checked.
Document?
Milord, may I be permitted to mention a matter, Milord? This relates to, Milord, disbursal of pension, but pension file has not been processed, Milord. The petitioner is about to superannuate in the month of January 2026. Milord, the matter was about to appear in the list on 3rd of December, Milord, but since it did not appear, I am mentioning it, Milord. This is an urgent matter. Representations have not been considered.
Lordship, may I permit to mention the matter for non-prosecution?
Give group 2.
My lord,
Group 2.
yes, Lordship. My lord, may I permitted to move to urgent motion?
No
My lord,
urgent motion.
My lord,
File it will be given.
my lord, 9th is the, my lord, online application last date,
No, no,
my
no.
lord.
Lordship,
My lord, kindly fix
No.
that in Monday, my
I'd like
lord.
to mention one matter.
No.
My lord, on
this
Monday,
matter
my
is-
lord,
You file it,
my lord,
we'll see.
kindly understand
No.
the
This
predicament
matter
of
is
my lord.
regarding the transfer of a primary assistant teacher.
Yes.
The distance between the house and the school is 214 kilometers, and the petitioner is the sole child of the.
Give it.
Okay.
May I seek my lord's kind indulgence to mention, my lord, one matter. The petitioner before your lordship is a primary teacher, my lord. The matter was directed to be posted in the month of March 2025. Be that as it may, the business of the Honorable Court, my lord, did not permit it to be listed, my lord, in due course. I am not getting, my lord, this suspension allowance, my lord, for more than 1.5 years.
Give.
I tell your lordship, serious allegation has been leveled against my client.
List করো।
My lord, kindly, my lord, last date of the online application
File
is
it.
my lord, 9th, my
I
lord.
cannot accommodate all and
My lord, on
everybody.
Monday, my lord.
No, it's not possible. You also know that.
Technical.
So kindly file it. If possible, we'll take it up.
72 hours before
All
72
cannot be
hours
taken up like this.
listed.
So it's your prerogative now.
Not be.
It's not your prerogative to file the application on 9th and ask the court to move, take up the matter. Is it possible? Humanly possible?
My lord,
What
last
prevented
date,
your client to file it prior to that date?
my lord, today,
Try 15 days back.
my lord, due to technical
No,
issues,
we
my lord,
cannot.
petitioner
I
could
cannot
not
do it
file
like
his
this.
online application.
What I
my
have
lord.
done is the applications which are filed on the last week, I have taken it up.
My lord, on Monday,
No, I cannot.
Tuesday is the my lord, last
File
date,
it.
my lord.
File, get
My
the
lord, I
date.
will file, my lord,
File the.
72
I cannot grant you leave.
72
No.
hours listing date.
Sorry,
cannot be
sorry,
given,
madam.
my lord.
Yes.
May I be permitted to mention matter, my lord, upon servicing to the other side, I am mentioning the matter, my lord. This instant read petition has been the wrong
Item
tagged
number.
to another matter, my lord.
Item number.
Item. This is not in the list, my lord.
Give it.
Item mat number WPA.
Mat?
Extremely sorry, my lord. Edit number WPA of 2779 of
What is
2023.
pension matter or what matter? This is mention or transfer? What matter is this?
This matter was filed by the challenging two notifications. My lord, the notification dated 15th of February 2022 and
Is it transfer matter, pension matter? What matter is?
no, not the transfer. There is the regarding the recruitment of teachers, the primary teachers. My lord. Yes.
You find out what is your case. Yes, Daku.
I'm praying for can you detect the matter with the another matters. I'm praying for detect the matter with another matter, my lord, which it has been tagged with another matter wrongly tagged by the order dated 5th of July 2024. Kindly fix any date, my lord. You take it.
Yeah, my lord, may I beg to mention one matter? It's a matter from Andaman, CPEN. My lord, may I beg to mention one matter? CPEN 48 of 2025. It hasn't been listed yet. It was filed in August 2025.
Arising out of which order?
Raising out of an order passed by your lordship on June 16, 2025. In WPA number 242 of 2025, it was passed in the circuit bench of Andaman Nicobar Islands.
Why cannot? Can you post the order which has been passed? How can I see that order?
My lord, it was already transmitted to your lordship's court, but it hasn't been listed yet. So if it can be heard on
What you do is you give the number.
Yes, my lord. It's CPAN
Chat box.
48 of 2025.
Give the number in the chat box. Let us check it, and you mention come back tomorrow.
My lord. My lord.
Give
Okay.
it in the chat box with the number.
My lord, I'm giving it.
Yes. আন্দামানে কোনো সিপ্যান আছে কিনা চেক করুন। Where is Mr. বিশ্বাস?
But ask for the private.
Mr. বিশ্বাস as a representative.
ওকে কাগজ তো
Whether this matter is going on sometime,
It'll take some time.
so whether we shall be released for 1 hour, just
1 hour we will take.
1 hour.
Yes.
Lord, in the last occasion, Mr. Shannal has initially, Lord, taken a point that the qualification with regard to date of these applicants is little cloudy, and according to Mr. Shannal and reading with the judgment of Devesh Sharma, that we do not have any locus with regard to the qualification of date. Lord, I'll satisfy your lordship, Lord, first that point that I do possess date certificate, and the date certificate and the certificate issued by the board itself has never been recalled, and by operation of the judgment, the same judgment, it cannot go. On the other hand, my submission is before your lordship that the Devesh Sharma judgment has rather substantiated my claim, and my date certificate cannot be touched. The subject lordship kind sanction, Lord. I'll be on the last occasion, Lord, did I hand over, Lord, the Devesh Sharma judgment? If not, Lord, I'm giving a fresh copy to your lordship, because
It is here. It is here. How many times will be?
The paragraph may not tally, Lord. That was the reason, Lord, your lordship is.
It is here.
It is. Now, your lordship, Lord. Not essentially, Lord, the Devesh Sharma's judgment was on the point, Lord. It has carried out from the judgment of the Honorable Rajasthan High Court, and which, Lord, has strike down and declared the notification of, Lord, 18 June 2020, Lord, as ultra virus. 2018, Lord, as ultra virus. Now, the Honorable Supreme Court, while dealing with, Lord, the judgment of the Honorable Rajasthan High Court, Lord, has came to a finding that yes, the notification in turn is not in consonance with the established rules and procedure, and they cannot be sustained. Now, my lord, I was, at the cost of repetition, my lord, I was saying before your lordship, my lord, that date of the judgment would be relevant because of the reason all these procedural aspect with regard to my qualification, with regard to TATE, and my certificate issuance by the board for qualifying TATE is prior to the judgment. This judgment, Lord, of the Honorable Supreme Court in Devesh Sharma, Lord, came in the month of August 2023. Your Lordship would kindly take note of the date. Mr. Shanal has also referred, Lord, the date. The date is, Lord, 11th of August. Your Lordship would kindly take note of that. But I will be placing, Lord, few paragraphs, Lord, from that judgment, which, Lord, subject to Lordship kind sanction.
11th August.
11th August 2023. Now, Lord, the judgment was not placed, Lord, in entirety, but however, the finding with regard to, Lord, the striking of or, Lord, declaring the notification as unconstitutional, and that particular paragraph was placed. With the leave of your lordship, Lord, I just want to place the rest of the paragraphs, Lord, in the concluding part of the judgment passed by the Honorable Supreme Court, Lord, in Devesh Sharma's case. Your lordship would kindly paragraph 80. Your lordship would kindly take it. That this is conclusive in respect of the persons who has appeared with B.Ed degree and the action taken in the interim period. Lord, we need to read, Lord, the judgment in a as a whole, Lord, not in a secluded part. Lord, your lordship would kindly, I just read paragraph 80. Having made the, Lord, determination, Lord, we all the time are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for applications from B.Ed qualified candidates for the reasons that till that time, when such an advertisement was issued by the Rajasthan government, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court has rightly observed, as under in paragraph 48, and I am also carrying the judgment of the Rajendra Singh Chotia. We are of the opinion that the state government could not have ignored the notification while inviting applications for REET, even like TATE, Lord, in West Bengal. Even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal, the same had to be stayed or set aside by a competent court before it could be ignored. Now, this was the finding. Now, the next paragraph is more important. Paragraph 81. What the Rajasthan High Court had stated above is the settled legal position. In a recent 3-judge judgment of this court in state of Manipur versus Surya Kumar Okram, this position that a statute, your lordship would kindly take note of that particular sentence. This position that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been reiterated. Now, my lord, the finding of this judgment of Surya Kumar Okram, Lord, I'll also place, because the sole contention of, Lord, my submission before your lordship, Lord, the day on 11th August 2023 should be the cut-off date, and the Honorable Supreme Court has reiterated that on and from 11th August 2023, the notification has no effect. Now, Lord, the question may arise that what would be the effect?
In that event, there was No occasion to file any clarificatory application.
I'll come, Lord. I have explanation and I'll try to impress your lordship, Lord. This was pertaining to the person who has already been recruited.
No.
Now, Lord,
if
these
your,
two
if your
paragraphs.
analogy is accepted by this court,
My lord.
in that event, those persons who were already appointed would not have filed an application for clarification.
Lord, your lordship would kindly, today, at present, Lord, your lordship would kindly appreciate one aspect, that at
What was
present,
that?
Lord, we are also having, Lord, DLED degree. So, Lord, this is pertaining, which is
Yes, yes.
directly affecting, Lord, my eligibility criteria. Now, Lord, so for TET is concerned, Lord, there is no guideline that who can appear for the TET and all. But in the notification, Lord, they have said that persons having B.Ed qualification can appear. But the board till date has not come up with a clarification that these candidates who have appeared in B.Ed with B.Ed qualification, their TET certificate has been cancelled. Now that is not there. On the contrary, Lord, I'll show in course of my argument that they have accepted this and they have acted on it. So, Lord, that's the reason, Lord. So, for the clarification part is concerned, Lord, this paragraph 80 and paragraph 81, Lord, is the clarification in respect of the effect. Now, that was, Your Lordship is. I'll place that. I'll place, Lord, that paragraph 8 of the clarification also, Lord.
Yes.
Now, this paragraph 80 and 81 makes it clarify. It is very, Lord, expressive in the language that the effect of the notification is stalled or, Lord, ceased from the date of delivery of the judgment. Lord, your lordship would kindly allow me to place Lord Surya Kumar Okram's judgment. ওই যে জাজমেন্টটা দেবেশ কুমারের রিলাই করেছে সূর্য কুমার ওকরাম ওইটা।
আচ্ছা।
This is reported in 2022. Oh, this is reported in 2029. Is 2022. Sorry, 2022. I mean, advance. 2022 19 SCC 723. Lord, the challenge was before the Honorable Supreme Court is with regard to, Lord, a saving act, Lord, which was repealed prior to that, Lord. I will not be troubling your lordship, Lord, with the whole judgment and factual aspect of the case. But since the Honorable Supreme Court, while dealing with Devesh Kumar's, Lord, in paragraph 81 has dealt, Lord, why the Honorable Supreme Court has taken that particular view, Lord, I will just place, Lord, that particular paragraph, which is at, Lord, paragraph 39 of the judgment. Now, Lord,
yes.
Your lordship would kindly take, Lord, the effect of, Lord, the principles that can be deduced from the law laid down by this court as referred to above are 39.1 is a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. Lord, I'm pausing here for a second, Lord, because of the reason till, Lord, 11th of August 2023, the notification of 18 June, Lord, was valid because it was not, this has not been declared ultra virus. This was in force. Now, subsequently, by a judgment of the Honorable Supreme Court, the notification has been struck down. Now, it was valid till, Lord, 18 April. Any action taken in the meantime, that has been protected in the, your lordship would kindly take, Lord, 39.2. After declaration of a statute as unconstitutional by a court of law, it is non-est for all purposes. It ceases on that day. Lord, it cannot be said, Lord, I'll come, Lord. 39.3, Lord, in declaration of a law, the doctrine of prospective overruling can be applied. Lord, that's the, Lord, spirit, and that was the reason, Lord, while the Honorable Supreme Court subsequently dealing with, Lord, the scope of the judgment has come up with a clarification. Lord, as I said, Lord, we need to read, Lord, conjunctively. Lord, we cannot disjunctively read, Lord, the judgment says this, and since the explanation is this, so you did not have any right. So, Lord, in a conjunctive reading of the judgment of Devesh Kumar, along with these judgments, which is the constitutional bench judgment, and framed the law with regard to the applicability of the striking down of a particular statute or, Lord, rules. Now, Lord, this 39.4 says, may I, Lordship would kindly take note of 39.3 also, Lord.
Yes.
Relief can be molded by this court in exercise of power under Article 142 of the Constitution, notwithstanding the declaration of a statute as unconstitutional. Lord, these are the 4 laws which is governing the field.
Yes.
Lord, we cannot say as on date that the pursuant to the notification, whoever has appeared and cleared their TATE examination, that cannot be questioned at this point of time, because the Honorable Supreme Court, while deciding Devesh Kumar in paragraph 80 and 81, has clarified that the effect of the judgment would be from 11th of August 2023, not before. So the all other subsequent observations or previous observations, because my learned senior friend has also referred, the applicants has also referred few of the orders of this honorable court, where this honorable court has declared that this should be subject to the result of the Devesh Kumar. The result of Devesh Kumar's judgment is in my favor. It's not that the Devesh Kumar's judgment has excluded me from every right. Rather, it has taken care and protected my right, and it said that since the effect of the judgment is on and from 11/8/2023, and subsequently it has also been ratified that it is prospective in nature. Now, Lord, again I say, Lord, we cannot read it in a piecemeal. Now, Lord, I'll also place the clarification part also. Now, after this judgment and after this observation, it cannot be said that my TATE qualification and appearance in the TATE and the issuance of certificate by the board has any cloud at all. Now, Lord, so for the clarification given by the Honorable Supreme Court in Devesh Kumar, Lord, this clarification came, Lord, in the month of April 2024. Yes. The paragraph 8 by London senior friend has also placed. Now, Lord, the law is well settled that, Lord, retrospective and otherwise stated. Lord, I take exception of, Lord, paragraph 80 and 81, and I say that any action taken prior to, Lord, 11/8/2023 has been protected by the Honorable Supreme Court in Devesh Kumar's judgment, citing a, Lord, constitutional bench judgment that the effect is on and from, Lord, 11/8/2023. My Lord, now, Lord, so far the clarification is concerned, Lord, your Lordship would kindly take, Lord, paragraph 6, paragraph 3 first, Lord. Yes, sir. সূর্য কুমার ওকরামটা, হ্যাঁ স্যার, সূর্য কুমার ওকরামটা পেয়েছেন স্যার আপনি?
না, ওইটাই বলছি 2022-19।
Kindly give me a second, Lord. The Lordship would kindly take, Lord, paragraph 3 first in the clarification which was filed by now, Lord, the application was essentially, Lord, paragraph 3, Lord, your Lordship would kindly take of the clarification judgment, Lord. Paragraph 3, it says, now an application has been taken out by the state of Madhya Pradesh, labeling it as an application for clarification, and the applicant seeks for us to hold that the said judgment ought to have been prospective application only. Now, this was the point of consideration before the Honorable Supreme Court, whether the judgment would be prospective in nature, because it was not expressly said. However, there were observations of paragraph 80 and 81. Now, in answer, Lord, to this application, the Honorable Supreme Court, Lord, says, the Lordship would kindly straightway come to paragraph 8. As it appears that a large number, yes, as it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of a eligibility criteria specified by the educational authorities. Lord, I take a pause here. Now, Lord, the appointment with B.Ed candidates and the qualification of TET with B.Ed, your Lordship would take this as synonyms, because the TET examination with regard to the state eligibility test, there was no argument advance, there was no whisper at all, and this particular issue can be equated, the qualification of TET can be equated with the appointment only, because there is no separate observation, there is no separate pleadings to that extent. So, my Lord, the Honorable Supreme Court was quite aware that any action taken, because there is an expression in paragraph 80-81, the cue is from paragraph 80-81, and that is the reason, Lord, the Honorable Supreme Court is said that I'll as it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of the eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. Similarly, the equity which has been created in our favor was also integrated part, Lord, in respect of deciding the appointment, recruitment of the B.Ed candidates, Lord, in the time while this clarification came. We accordingly hold that the judgment delivered by this bench on 11/8/2023 shall be prospective operation, full stop. So this is a sentence, Lord, which says that the operation of the judgment will be prospective in nature.
Then the next sentence is,
No, I'll come. Now, Lord, this clarification with regard to, Lord, the recruitment, as I said, Lord, your Lordship will not find a single averment, pleadings, or discussion with regard to the, Lord, TET qualification. This is all about recruitment. Now, Lord, your Lordship has by this time seen.
In the clarification, it says that the prospective effect of the order will be applicable in case of persons who were appointed. If we go through the entire paragraph, in the last sentence, it says, suppose your case is you are about to appear. The court has also clarified.
No.
Let me put it, then you can answer. Mere selection of such candidate. Now there is a selection. One person was appointed, court protected him. Court also clarified that mere selection of such candidate or their participation in the process will not entitle them for the benefit under our present order.
This is recruitment. Lord, I said, Lord, the recruitment with regard to, Lord, B.Ed candidate.
But see, the persons who have participated in selection process, they are also not protected under that order. The court clarified that who has been appointed, I give them this leverage of having its prospect. And in one sentence, I will just refer to page 7 in the given facts. In the given facts, we find that the question as to whether a judgment will be prospective or not was not stated by us in the judgment delivered on 11th August 2020. Now it starts with a sentence, ordinarily a judgment acts retrospectively unless it is specifically stated to be otherwise. So in Devesh Kumar, court did not say that it will be prospective. Now it clarifies that ordinarily it is retrospective unless it is stated. Now it states that it is prospective in case of persons who were appointed.
Now, Lord, your Lordship would kindly take note of that, Lord. In the said Devesh Kumar, that is the reason, Lord, at first place, I have placed paragraph 80 and 81. That has qualified, that has taken care of my right
because the only one observation in respect of the B.Ed candidates are in paragraph 80 and 81. The court affirms the finding of the Honorable Rajasthan High Court in respect of non-calling of the B.Ed candidates in participating to the recruitment process. So that window with regard to participating in the recruitment process was open till the date of 11th of August 2023. So that was not done. That has been deprecated by the Honorable Supreme Court. And the Honorable Supreme Court, taking note of that, says that they ought to have been called. I qualify there in paragraph 80 and 81. So the clarificatory part with regard to Lord recruitment is concerned, because there are two phases. Lord, I'm trying to impress before your Lordship, TET is one thing and appointment to the post of primary school teacher is a different thing. TET is a qualification to appear in the recruitment. So this is all about recruitment in Devesh Kumar's clarificatory judgment. So it's not about qualifying, Lord, in TET. So far, participation is concerned, Lord, there are two phases. One is participation. One is participation in respect of Lord in the presence of the recruit notification, and the another one is participating in Lord the recruitment process and thereafter being selected or not selected. So we need to segregate Lord two parts, because the first challenge was by Mr. Shannal that I am not a TET qualified candidate. So in answering that question, Lord, I beseech your Lordship, Lord, to take note of paragraph 80, 81 and the principle of prospective, Lord, applicability of the judgment. Because judgment has taken care of. The prospective applicability is in respect of the person who has already been appointed. And two issue, TET qualification and recruitment process are different. Because it is a minimum qualification.
Yes.
Because that is, I cannot claim my right of recruitment based on the notification. Because, and this, your Lordship has read, Lord, that the mere selection of such candidate of their participation in the process will not entitle them for a benefit under our present order. Now, Lord, I'll explain that. Lord, your Lordship would kindly allow me to place the whole paragraph 8. It says, Lord, we accordingly hold that the judgment delivered by this bench on 11/8/2023 shall have prospective operation. Full stop. But
this I have understood that if you read Devesh Sharma and Sukram together conjointly, it gives a prospective effect.
Obliged.
Correct. This is what you are trying to impress upon. Now, what about this sentence? How do you clarify that ordinarily a judgment acts this in the clarification order in Devesh Sharma? The court says that ordinarily retrospective. Now, retrospective goes back to 2018 when the amendment was put in vogue.
No, it says not prospective operation.
No. Given facts, the clarification order in page 7, ordinarily a judgment act retrospectively. The court has, in the first judgment, it says Sukram.
With greatest humiliation.
Now, after when the application is filed by Madhya Pradesh High Court, Madhya Pradesh, state of Madhya Pradesh, this clarification comes in clarification. It says that ordinary judgment acts as retrospectively. Retrospectively goes back to 2018.
Lord, that is the reason, Lord, I said, Lord, subject to kind sanction, Lord, we need to read the clarification conjunctively with the finding of the original judgment. The original judgment, Lord, if your Lordship kindly allow me again, Lord, I can place paragraph 80 and 81. Because paragraph 80 and 81 came on the in the month of August 2023, 11th August. There, the right of these persons who have appeared with the B.Ed qualification has already been protected. They have not been thrown out. Because that's the spirit of the Devesh Kumar judgment. Now that is, and the Honorable Supreme Court, while dealing with Lord, the right, has relied on a judgment of the Honorable Supreme Court, which now that is the reason, Lord, I was trying to, Lord, submit before your Lordship, Lord, that we should not, Lord, read it conjunctively. Should read it, Lord, conjunctively. The paragraph 80, 81 and, Lord, the clarification. How can we ignore, Lord, subject lordship kind sanction, the paragraph 80, observation of paragraph 81 and 80? May I just place it again for your lordship's convenience, Lord? Kindly, Lord. Lord, may I just read it again for your lordship, Lord?
ক্রিমিনাল লয়ারদের লিখতে আসছে কাল মামলা মিস করেছিস
আজকেও করেছি। Having made the above determination, Lord, the determination is that the notification is, Lord, unconstitutional. We all the same are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for application from B.Ed qualified candidates for the reasons that till that time when such an advertisement was issued by the Rajasthan government, I'll be beseeching your lordship to read, Lord, that the board or, Lord, the state of West Bengal, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the, your lordship would kindly read this as, Lord, state of West Bengal or board, till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed as under. We are of the opinion that the state government could not have ignored the notification while inviting applications for REET. Your lordship would kindly read date. Even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal, the same had to be stayed or set aside by a competent court before it could be ignored. So the right accrues here in this paragraph. That it has been taken care of by, so subsequent clarification, as I said, that is only to the extent that the person who has already been recruited by the particular state. আপনি বলছেন না কেন? আমি
বলছি না তুই এক জায়গা থেকে পড়ছিস তো এসব অনলাইন হয়ে গিয়ে প্রবলেম।
হ্যাঁ, এটা এসসিসি অনলাইন, এটা now, Lord, the paragraph 81 is supplementing, Lord, paragraph 8. Lord, may I just read it again for your lordship? Lord, that's my case. It stays.
Read it.
Lord, now this is the, Lord, these two paragraph has decided my fate. The clarificatory part is only to the extent of the person who has been recruited. Now there cannot be, Lord, ambiguity, Lord, in the finding, because the Honorable Supreme Court was cautious that by this time many things has happened. So not only, Lord, the candidates who are having B.Ed qualification has been protected, including the person who has been appointed, they have been also, Lord, protected. We cannot, Lord, take it as a piecemeal. We need to read in seriatim. 80, 81, then, Lord, paragraph 8, Lord, the clarification. If you read, Lord, in seriatim, Lord, it protects, Lord, the person who have applied, because the any equity, Lord, created before, Lord, the notification was struck down by the Honorable Supreme Court, that cannot be taken out. Lord, that was the spirit even in the explanation given in paragraph 8. The equity created, Lord, here I'm also, Lord, standing on the same footing. Lord, that was the reason, Lord, I was beseeching your lordship, Lord, to read or
5 মিনিট আর নিবি তো?
আপনি জান আমি 5 মিনিট কেন আরো একটু সময় নেব, আপনারই কতগুলো করা অর্ডার।
জাস্ট আই এম টেকিং 5 minutes টাইম।
Yes, next.
So, Lord, this cannot be said, and in the garb of this judgment, the finding is in my favor. It's not that it is excluding my right of participating in TATE and qualifying for the recruitment process. And it is the board who has acted on this notification, on this judgment, and thereafter have issued the TATE qualification certificate. Now, till date, as I said, Lord, in my opening submission before your lordship, that till today, in the board's website, Lord, it is appearing, all the candidates, Lord, TATE qualification certificate is appearing, and anybody can log in and download the certificate. The certificate has not been recalled by the board itself. So Mr. Shannal appearing for the board cannot come and say that these people are not TET qualified. So their primary eligibility is not meted out. So in that score, Lord, I beseech your Lordship, Lord, these are the report and supplementary. It's so, but বিল্লদল ঘটছে কিছু করেন না দাঁড়িয়ে করো উপায় যাও now Lord this was Lord this is my submission in respect of Lord the judgmental effect of Lord Devesh Kumar's judgment. Now Lord there are few factual aspects Lord in response to Mr. Shannal's Lord argument that the terms of the board placed before the court and the submission made by Mr. Shannal is little contradictory. In a recent Lord proceedings where Mr. Firdaus Samim appeared for the petitioner in WP number 5122 of 2024, Lord, where a similar kind of Lord issue, a connected issue Lord was raised, where the board was directed to file a report. The report was made available to Mr. Firdaus Samim. I know Mr. Samim will be little hesitant, but the order observed and the copy of this such report we have got it. Lord, your Lordship would kindly take, I just supply, because since it is not been, I was not party to the proceedings and I'm relying on a document which has been placed by the board. Now, that is the reason, Lord, I'm referring the order, Lord. The board is directed, Lord, it is in this. তোরা appear করছিস তুই নিজেই it is internet, so please take it. WP number 5122 of 2022 দেখাচ্ছি তোমাকে WPA 5122 of 2024 Shubhranshu Pathak and others versus the state of West Bengal and others. The petitioner has
5122 of
2024. Lord, your Lordship would kindly take these three orders. May I just read it for your Lordship and for my friends also. At a copy. Baba. Petitioner had participated in the second paragraph, Lord. Order dated 5/11/2024. Recently, Lord, 1 year back. The petitioners have participated in the test TET 2022 conducted by the board education with B.Ed and DLED from now this is B.Ed or DLED. The Honorable Supreme Court in two successive decisions in the case of Devesh Kumar Sharma reported in such and such, and Jaivi Singh is Lord NIOS. So Lord, I'm not saying it was held that B.Ed is not an eligible qualification for appointment as a primary teacher. So the 18 months diploma conducted by NIOS through ODL mode. The petitioner are claiming that they are also possessing 2 years regular diploma in elementary education from the board and are paying that their eligibility to get the appointment as primary teachers may be tested on the basis of their said diploma. The board is directed to file a report on the said prayer of the petitioners on the next date of hearing. Now, this was the direction given by the court, and thereafter, Lord, a report was filed. Now, Lord, this is the report filed by the board. আরে ভাই তোদের কপি তোদেরকেই দেবো
হঠাৎ বলছি না তাহলে বললে বার করে আনতাম ফাইল থেকে বলে দিই না কেন ওভার ফোন যেটা দেখাবো দাদা
Let me I just I've got one extra copy, so please take one.
দে একটা দিবি
May I just place with regard to that, Lord, query of the court, what is the terms of the board? Lord, it says, Lord, I'm first part, Lord, I'm skipping over because that's the compliance. Lord, may I read it? By order dated 5/11/2024 passed in WPA 5122 of 2024, Shubhrangshu Pathak, the Honorable Justice Bishwajit Basu directed West Bengal WBPE to file a report on the said prayer for petitioners on the next date of hearing. The petitioners are claiming that they are also possessing 2 years regular diploma in elementary education from the board and are praying that their eligibility to get the appointment as primary teachers may be tested on the basis of the said diploma. Certain dates considered by the board to be relevant pertaining to the claim of the writ petitioner as stated infra. 29/9/2022, TET 2022 notification was issued by the board, thereby allowing B.Ed trained application, trained application to sit in the TET 2022. 18/10/2022 in Ujjwal Haldar's case, which has been placed before your Lordship Lord on the last occasion, such and such notified shall abide by the result of the SLP such and such is appended with this report. 7/11/2022, in view of the above order dated 18/10/2020, it was notified by the board that B.Ed candidates applying for TET will be allowed to appear in the Teacher Eligibility Test 2022 subject to final result of the Honorable Supreme Court. The final result of the Honorable Supreme Court is in my favor, not against me. The report also says that. That's the stance of the board. 10/2/2023, TET 2022 result was declared. Many candidates who applied in TET 2022 B.Ed did also pass out. 29/4/2023, TET 2022 eligibility certificates were issued to the TET 2022 pass candidates. 11/8/2023, the judgment blood Honorable Supreme Court of India in Devesh Sharma versus such and such unequivocally held that the B.Ed is not a proper training qualification for being considered for the post of primary pan-India. 13/2/2024 in Shilpi Sen's matter, in paragraph 5 to 12, direct infra, which the applicants has referred. Now, in the order has been quoted. Then paragraph 3. The candidates passed in TET 2022 with B.Ed training qualification may be considered as TET 2022 passed candidate. May I just paragraph 3, bottom in say paragraph page 2. The candidates passed in TET 2022 with B.Ed training qualification may be considered as TET 2022 passed candidate, since the candidates were already declared as TET 2022 passed candidate before came into force for the order of the Honorable Supreme Court of India on 11/8/2024 in Devesh Sharma's case. So, this is the
go on reading.
Such and such has not specifically stated about the value. But I'm saying that is what my argument is. Came into force of the order of Honorable Supreme Court in India on 11/8/2024 in Devesh Sharma's case. And the Honorable Court, in its judgment dated 11/8/2023, has not specifically stated about the validity of a TET pass candidate with B.Ed training qualification. The West Bengal Board of Primary Education, being the examining and recommending authority, will verify the eligibility of a candidate for being recruitment as a primary school teacher at the time of scrutiny and verification under the recruitment process to be notified as and when required as the NCT norms and solemn order of the Honorable Supreme Court on such and such. If the candidate fulfills the eligibility criteria at the time of recruitment notification as per NCT norms, they will be allowed to participate in the recruitment process. Lord, I am saying that the argument, Lord, advanced before your Lordship today by me, and the advancement of argument by Mr. Shannal is in variance because of the reason this is the board stance before a competent court of law. Now Mr. Shannal comes and challenges, Lord, the now, Lord, your Lordship would this is the stance of the board, because this report has been filed by the Secretary of the board, and Mr. Bishas was also, Lord, appearing in the matter. Mr. Atul Bishas was also appearing. No, I'm not saying. I'm saying that my TET qualification cannot be challenged. Lord, I have not come to the level of, Lord, recruitment. So for eligibility criteria with regard to recruitment process, Lord, I have also answers. So, Lord, this is only pertaining to, Lord, TET qualification. Lord, your lordship would kindly take, Lord, the supplementary affidavit, Lord, which I have given on the last day with this. I have served upon, Lord, the board as well as, Lord, the applicants. Lord, may I just explain the documents, Lord, which is annexed, Lord, on and from paragraph page 4. This is the TATE certificate. The first annexure is the TATE certificate of the applicant. Top, Lord, teachers eligibility TATE 2020. Lordship has got, Lord, 2022. Lord, he is qualified. Remarks, Lord, as qualified. Now, Lord, the next is page is 5, which is the primary teachers recruitment form. Lord, where I am seeking, Lord, liberty to participate, and because of my result has been withheld, so that is the reason the first prayer I have come and wanted to fill up this particular form. Now, Lord, it says about, the Lordship would kindly take, Lord, the training qualification.
Yes.
Third, Lord, first is personal details, second is academic qualification, the third is training qualification. Name of the examination, 2 years diploma in elementary education, state, West Bengal, examining body, board, session 2022-2023, which is, Lord, I am 2023-2025. Now, Lord, year of passing 2024, full marks such and such, obtain such and such marks. So, Lord, this is the form he has filled up based on B.Ed degree, passed the TATE examination. Now, Lord, your lordship would kindly come to page 6. The forms in respect of TATE examination, which was held in 2022. Now, the first is personal details. Then is, Lord, your lordship has got, Lord, academic details. Then, Lord, training qualification. Your lordship would kindly take, Lord,
you're reading from which?
Page 6. Paragraph 4 is the TATE, page 4 is the TATE certificate, 6 is the form which I am intended to fill up, and the next page, page 6, is the, Lord, TATE form. In 2020, the way, Lord, I have filled up the form. Name of the examination in the training qualification, your lordship would kindly take, Lord. First is personal details, second is academic qualification, third is training qualification. In the training qualification, your lordship would find, Lord, the left name of the Bachelor of Education, B.Ed, West Bengal, then, Lord, Bardhaman, and then, Lord, session of B.Ed, then when, Lord, passed, then year of passing 2019. So this form, Lord, to show the queue that the person with B.Ed qualification appeared in TATE, passed TATE, board has taken a chance that already the person, and then in page 5, I have shown in this recruitment process, they have been allowed to fill up the forms. So my contention is that you are allowing the person to appear in the examination with TATE qualification of 2022 with B.Ed degree and subsequently DLED degree course. So, Lord, you cannot throw me out, and this would be a clear violation of Article 14 because you are treating the equal with inequality. Because this is one candidate I can show. There are many, I guess. There are a number of persons who have been allowed to participate in the recruitment process based on the TATE certificate of 2022. So this question with regard to that I do not hold the minimum eligibility criteria of being passed in TATE does not stand. One, to sum up, to one, the effect of the judgment, which is to be read in the positive aspect, and the Honorable Supreme Court has given explanation. Two,
yes.
Two, that the board has taken a chance before the Honorable Single Bench in a pending proceedings and filed a report that the persons who have passed TATE 2022 with B.Ed qualification, they will be allowed to appear, allowed to participate in the recruitment process. And third, the candidates having TATE degree of 2022 has been allowed to participate in the recruitment process. So these are my submissions with regard to TATE qualifications. And the most surprising feature is that since our certificate with regard to TATE is appearing in the website and in the database, we are allowed to open the forms. We are filling up the forms, but we are being rejected only on the score that our session with regard to DLED degree has not been completed and our result has not been published. So that's the primary concern. Lord, I say, Lord, to add up, Lord, I say, subject to lordship kind sanction, our result has been withheld only to deprive us so that we cannot participate in the recruitment process. Because the session of the DLED course is June to June, June to July. In 2023, July it was started. It ought to have been completed in July 2025. We are in the month of November. Yes, I'm sorry, December, first November. But till date, the result has not been withheld, declared. Now, this issue, the board in various occasions takes various stances. In the previous recruitment process in 2022, the board did the same thing. The result was not published. Part 1 examination was concluded. Part 2 was not there. So ultimately, the candidates like us, with TATE and DLED degree, your lordship would kindly keep aside the B.Ed degree for the time being, because that is only relevant for the purpose of TATE. So for this recruitment is concerned, by this time, I have acquired the eligibility criteria of TATE qualification and DLED degree, because that's the training I have completed. I've said in my opening submission that I am already completed my course. I'm awaiting for the results. So for the next limb of submission with regard to the eligibility criteria and participation in the recruitment process, I'm making my submission. So I am, as on date, TATE qualified and having a qualification of completion of the DLED degree. Now, on the last occasion when the recruitment process was started in the year 2022, the same thing happened. No publication of the result of the DLED. Batch of candidates approached this honorable court, but this honorable court directed the board to publish the result, and the board also undertook and submitted before this honorable court that we are publishing the result tomorrow. 29. Page in my applications, I have annexed the order. Your lordship would kindly take the 5th volume. I have said, your lordship, repetition. 22. Sir, my lord, your lordship would kindly take note, Lord, annexure P10 622. No, I'm only for the purpose. আমার repetition is 622. Lord, this is, Lord, as I've said, Lord, in this matter, I'm told that the learned advocate for the West Bengal Board of Primary Education that today, on 29/9/2022, the result of DLED Part 1 will be declared. And digital mark sheet will be sent to the different institution. Now, this was in respect of Part 1, but here in our case, we have completed Part 1, appeared in Part 2. Result is not being published. We have completed the course. All the persons who were undergoing the course will get the digital mark sheet tomorrow and 30/9/2022. It was further been stated on instruction, Mr. Satan Sach, for the West Bengal Board of Primary Education that TATE qualified candidates who are undergoing DLED training session 2022 and qualified DLED Part 1 2022 examination will be given opportunity to apply in the recruitment process to be initiated by the board. Now, on the last occasion, they have also allowed the ensuing candidate to participate in the recruitment process. That was the consent given by the board. Now, this year, they are very strict and they say, unless you possess a qualification on the date of last date of the filling up of forms, you will not be allowed to participate in the in the in the recruitment process. So, this paragraph, he has also submitted that the opportunity will be given to all persons who are undergoing DLED course of the sessions 2020-2022. Therefore, I find that the grievance of the petitioner is redressed by the stand taken by the board, which is beneficial to all. Okay. So, this order, the other batch of persons who had the requisite qualification and completed DLED degree, they have challenged the order before the Honorable Division Bench. Now, by this time, the hearing of the appeal could be taken up. In the meantime, the recruitment process was not concluded. It started and the interview was about to be taken. At that juncture, the order of this Honorable Single Bench was set aside by the Honorable Division Bench. The Honorable Division Bench held that the benefit should not have been extended to the candidates who were ensuing the DLED course. The order was travelled to the Honorable Supreme Court by the same petitioners like us who were in pursuing their. The Honorable Supreme Court decides the issue and answers two questions. One, that it was the incumbent upon the board to publish the result before the recruitment process starts, and two, the cut-off date with regard to the eligibility criteria. Now, your Lordship would kindly take that judgment, the writ petition order, I have referred at page 622, Lord. This is the order of the Honorable Division Bench. No, the Honorable Supreme Court. Lord, I'm sorry. It Dagmar আছে. Shoben Palet, Supreme Court judgment. It is. Yes. Lord, this, Lord. No. Lord, the paragraph 2, Lord, the issue involved in this case relates to the appointment to the post of assistant teacher in primary school in the state of West Bengal. This post is governed by the West Bengal Primary School Teachers Recruitment Rules 2016, and the qualifications for appointment to the said post are prescribed in Rule 6, which is extracted below from the ready reference. So the next paragraph is also important. In this case, we are concerned with sub-rule 2 of Rule 6. This sub-rule was later amended by a notification dated 22nd of December 2022 in the following terms. And this particular rule was referred by Mr. Shannal while advancing argument.
না আমি সাইড করিনি
আপনি পড়লেন যে cut off date.
No, I have not cited this judge.
No, you have not, but you have referred the rules. No, that is what I'm saying. Now, Lord, paragraph 4, Lord, it says, as it evident from the above, the minimum qualifications specified in Rule 6 of the Recruitment Rules 2016 will be those that are prescribed by the National Council for Teachers Education, a body constituted under the National Council for Teachers Education Act 1993. In exercise of the power conferred by subsection 1 of section 23 of the Right to Children to Free and Compulsory Education Act, by notification dated 23rd August 2010, the NCT laid down the minimum qualification for a person to be appointed as a teacher for class 1 to class 8. The qualifications are amended from time to time, and the qualifications that were prevailing at the time when the recruitment notification for appointment of assistant teachers primary in the state of West Bengal was issued were those prescribed by NCT in its notification dated 29/7/2011. The relevant portion of the said prescription is extracted here and below, and the minimum qualification has been given. ভালো একটু দেখে নিই। Now, Lord, paragraph 6, Lord, I'm skipping, Lord, may I read the whole? In the above referred legal regime governing the appointment to the post of assistant teachers, that the appellant's aspiration and endeavor to join the post advertised on 21/10/2022 came up for consideration. The relevant factual background is as follows.
Yes.
As the mandatory minimum qualification for the post, Lord, it is the same notification in 2022, whatever was the notification, it is just a replica in 2025. There was no change. So for the minimum qualification is also concerned. But as I said, Lord, I was trying to, Lord, answer the question of minimum qualification. Lord, here, Lord, the answer is, as the mandatory minimum qualification for the post of primary teacher in the state is a diploma in elementary education, which I hold today, a 2 year course conducted by the West Bengal Board of Primary Education constituted under the West Bengal Primary Education Act 1973, the appellants enrolled themselves for 2020-2022 batch of DLED. It was always been the practice that a new batch would commence from the 1st July of a year and conclude by the second successive year, which in the present case would have been 30th June 2022. Well, my case is also like that. The outbreak of COVID-19 pandemic and problems with the constitution and functions of the board delayed in 2020-2022 batch, leading to a situation where the normal and natural conclusion of the 2022 batch by 30th June seemed uncertain. The appellants were concerned that they may lose the opportunity to apply and participate in the recruitment process that was to commence with the issuance of a notification in October 2022. With the apprehension and anxiety about the fact that many of them could cross the age bar if they did not participate in the upcoming recruitment process, they approached the Calcutta High Court by filing writ petition under Article 226, in which they prayed us, Lord, which is akin to our prayer, Lord, that we also, Lord, want to complete and Lord, to publish the result before the last date of the applications, Lord, which is akin, Lord, I'm not troubling with Lordship, Lord, with the Lord prayers of the writ petition, Lord. Now, Lord, there is also a prayer for stay of the recruitment process. Lord, here also, Lord, we have also prayed for stay of the recruitment process till, Lord, the result of the Part 2 examination is declared. In the meantime, to obviate the inactive functions of the board, the government constituted an ad hoc committee, and the president of the board took charge on 24/8/2022. Along with the president, the deputy secretary of the board also took charge on 26/8/2022. After taking charge, the officers took stock of the situation and realized that the DLED batch for the 2020-2022 was already delayed and urgent action was required to be taken. It is evident from the record that Part 2 session of the 2022 batch ended on 30th June 2022. In our case, also in 2025, it is ended. And the examination for that purpose, Part 1 theoretical, was conducted between 15/7/2022 and 18/8/2022, which was anyway far beyond 30th June 2022. That normal conclusion for any DLED batch. So even if, Lord, we can also be termed as abnormal, because this ought to have been concluded in July. We are in December.
কোন পরীক্ষা পাস করেছিস এক মাসের কোর্স শেষ হবে
হ্যাঁ,
কোন পরীক্ষাটা বলতো
সব পরীক্ষাতে। When the writ petition came up for hearing before the High Court, I take the book of Mr. Shanna. It cannot be a chance that if the examination is taken in one date, obviously the result will come after 10 months. This cannot be a practice. If the action of any statutory body or any state as under Article 12 of the Constitution of India is vitiating right and taking away right and creating hindrance in exercise of the right, that court ought to have taken should take a step, because we cannot accept abnormal things. It's a normal thing that if I have participated and take admission in a course, the result would come within stipulated time, because that's the function of a state, that's the obligation of the state, to function correctly, properly, to secure the right of an individual. That's the challenge before your lordship in my writ petition also.
Your notice you indicated on the first date of hearing that they have completed their course, now they are to leave the institution.
Yes, but I'll come. I'll refer.
So what
that
was the
lot-
date of that notification?
the June 30th June. Your lordship, 588. Your lordship would kindly take note of that particular document. Lord, I'm bow down to your lordship.
In
Lord,
normal case, Mr. Sannal, when is the result is to come up? In normal cases, previously also you have conducted DLED. So if a June candidate completes the course in June,
My lord,
what
I
is the
tell you,
tentative?
lordship, this normally takes 6 months, 7 months
6 to
after
7.
the completion of the examination,
Sure.
because it
But
is
that-
statewide examinations. It has to be checked up, published, everything. Lakhs of candidates. It's not that Malad one or it's lakhs of candidates.
Okay. So, my lord, that cannot be a normal practice. That's the challenge before your lordship. As I said, the action of the state machinery is dependent on the beneficiary of the people. The state should act beneficially. They cannot take away the right. There, my lord, the court intervenes and secures right, my lord, of the citizens.
Yes.
The individual, my lord, is protected by the Constitution of India. The state machinery has obligation to perform. Now they cannot take a plea that every year we do it after a year, 7 months, 8 months, 10 months. That cannot be the rule, because the rule says that the course would be of 2 years, and I will be thrown out from the institution, and I loiter in the area, but he will not publish my result. That's not the protection of an individual.
So the rule does not specify any specific time period in which the result has to be.
My lord, that is the challenge in the writ petition also. We have prayed for declaration of the result of the examination. That's the challenge here in the writ petition also.
Yes. Next.
Jan? The I'm sorry, my lord, the paragraph 10, when the writ petition came up for hearing before the High Court on 21st September 2022, the Learned Counsel for the board sought time for taking necessary instruction. When the Learned Single Judge of the High Court again took up the writ petition with a petition a week thereafter on 29th September 2022, the counsel appearing on behalf of the board, having obtained instruction from the government board, informed the court that the result of the appellant DLED would be declared that very day, that is 29th of September 2022, and the digital mark sheets would be sent to the different institutions. Now they become super proactive. In jet speed, they declare result and it will be sent digitally to everybody, and they will facilitate the person ensuing candidates to appear in the examination. Now this year they do not want, so we have to bear their arbitrariness that yes, this year you don't want, that year you wanted, so you have done it instantly in a supersonic jet. Yeah. And the High Court was also informed, please, Mr. Biswas, do not disturb. The High Court was also informed that the candidates like the appellants who are TET qualified and who are pursuing DLED course for the session 2020-2022 and had already qualified in part 1 examination will be given an opportunity to participate in the recruitment process to be initiated by the board under advertisement dated 21st of October 2022. Lord, your lordship would kindly visualize one aspect. the act of arbitrariness is so apparent that cannot be accepted by court of law. On last occasion, when the recruitment process was initiated, they took a stance that, well, we will allow the pursuing candidate and we will allow the candidates who has only passed part 1 examination. Because ultimately the recruitment process, when it will be completed, he will also completed the DLED degree. Now here we are in a situation where we have already completed our course, but we are not being allowed to participate. Now, this arbitrariness in respect of one recruitment process and another recruitment process, which is the present recruitment process, Lord, they cannot have any explanation. It's not in their based on their whims. There has to be a uniform rule of law. And as I said, Lord, the experience is required. It is only the action of the respondent that they are withholding my result for which I am unable to participate. It's not my education which is steering at. It's not the experience which is not being counted. It is the result. Because I have already participated and completed my course. Now, the next page, in view of the statement made on behalf of the board, yes. On behalf of the board and without any further consideration, the writ petition was allowed and disposed of with the following direction. Lord, I have placed that particular order, Lord. That order, Lord, I have given to your Lordship, Lord. I'm skipping over that part. On 29/9/2020, the date on which the learned single judge allowed the writ petition, the board issued a notification indicating that the result of the DLED Part 1 examination held in the month of July for session 2020-2022 is published. And in terms of the said notification, the candidates were allowed to avail post-publication review or scrutiny of their performance within the prescribed time. The publication of the result was also intimated to the various institutions, and the students were permitted to receive the digital mark sheets. The exercise was intended to enable the applicants to candidates to participate in the recruitment process on the same day on 29/9/2022. Yet another notification was issued indicating that the board is going to recruit TET qualified candidates for appointment to the post of assistant teacher in the vacancies that may be indicated. The intendment of this notification is in the clarification and declaration that candidates like appellants who are TET qualified and had undergone DLED training and qualified for the Part 1 examination can participate in the recruitment process. It was also indicated that the recruitment notification and application form will be made available on the website with the effect from 21st October 2022. As it was contended by the respondents and the acceptance of the High Court that this notification dated 29/9/2022 itself is the recruitment notification, in order to contrast it with the subsequently issued actual recruitment notification dated 21 October 2022, we have reproduced both of them. Notification of this, the notification has been given, Lord, where the vacancies were also declared. So, Lord, I'm skipping over this part. Lord, why I'm placing this judgment, Lord, as a whole, because that answers the questions of Mr. Shannal. Mr. Shannal, which has taken, Lord, a plea of cut-off marks, cut-off date, Lord, and says, Lord, on the date of notification, we must post the requisite qualification. This was also being argued before the Honorable Supreme Court. The same argument was advanced by Mr. Shannal, but that was negated, and the court, Lord, held otherwise. Because that is the reason, Lord, I've shown your Lordship in paragraph 3 that the Honorable Supreme Court was aware that the recruitment rules has been amended and subsequently amended rules has been incorporated. Based on that, also this view came. That is the reason, Lord, I'm placing the judgment as a whole. Lord, that answers everything. Now, kindly excuse me for a second, Lord. Following the above referred notification, the recruitment notification was in fact issued on 21/10/2022, which is in our case not the subsequent notification in November, 19th November. The board in its submission before the division bench contrasted the previous notification dated 29/9/2022 with the recruitment notification dated 21st/10/2022 and asserted that the latter alone is the recruitment notification. The recruitment notification dated 21/10/2022 is reproduced for ready reference. So, on the last occasion also, in previous recruitment, we have also said that the subsequent notification, which is 19/11/2025, is the last notification for recruitment. But now today in court, the board comes and says, no, the September notification is the recruitment notification. This has also been clarified, that the board cannot take these different turns. But I'm skipping over the notification because this is akin to the November 11, 2025 notification. Now, paragraph 14, it is clear from the above referred notification dated 21st October 2022 that 1. It invites online application for recruitment to the post of assistant teachers. 2. It also specifies that TET qualified trained candidate, including the appearing candidates for the sessions 2022 in DLED, special B.Ed course will be eligible for participation. 3. It mentions that there are 11,765 vacancies and further notifies that the recruitment shall take place under Recruitment Rules 2016. With this analysis, there cannot be any doubt about 21/10/2022 being the recruitment notification. This controversy must end here. So that's the finding with regard to what would be the notification, recruitment notification. The appellants applied as per the recruitment notification dated 21st October 2022, obtained their course completion certificate on 29/11/2022. And the final result of part 2 of the examination were also declared on 30th December 2022. Interviews commenced in December 2022, and the process was moving towards completion. At this stage, questioning the legality of the order passed by the single judge, the private respondent who possessed DLED qualification as on the date of recruitment notification dated 29/9/2022 filed writ petition, the earlier notification. The submission of akin to the submission of the applicants who have filed the CAN application. I am not giving you any answer. I am submitting before the court.
Yes. Yes, continue.
Now, my lord, before the division bench of the High Court contending that the appellants are ineligible and their candidature must be rejected. The primary contention was that the appellants did not possess the minimum qualification as of the date of recruitment notification, and that the board could not have relaxed the recruitment rules permitting the appellants to participate in the recruitment process. The division bench of the High Court, by its order dated 27/2/2023, asked the board to file an affidavit indicating the circumstances in which the recruitment process was initiated, as well as the steps taken by the board in conducting 2022-2022 DLED course. In compliance with the High Court's order, the board filed an affidavit. The relevant portion of the affidavit is as follows. My lord, may I just, Lord, read the relevant portion, Lord. Now, this has been quoted later on, so Lord, I'll place from there. But your Lordship would kindly continue, Lord, with paragraph 17. Finally, the order impugned before us, the division bench of the High Court allowed the appeal and set aside the order of the single bench. The solitary factor that impressed the High Court is simply that as Rule 6.2 of the Recruitment Rules 2016, as amended in 22nd of December 2020, unambiguously specified the eligibility qualification required as on the date of advertisement. Candidates must possess the eligibility qualification as of the date of the advertisement, 29/9/2022. Firstly, the High Court treated the date of notification dated 29/9/2022 instead of recruitment notification dated 21st October 2022 as the recruitment notification, and secondly, it construed the rule to have prescribed a cut-off date for qualification. In this view of the matter, the division bench proceeded to set aside the later part of clause 3b of the notification dated 29/9/2022, enabling candidates like appellants to participate in the selection process, virtually holding all the appellants ineligible for even participating in the selection process. Lord, the order, Lord, of the Honorable Division Bench was also, Lord, quoted. Having heard the parties and considering the materials placed, this court is of the clear view that the board cannot travel beyond its own recruitment rules. Apropos, the above discussion in 2016 recruitment rules as amended by the notification dated 22nd December 2022 unambiguously specifies the eligibility qualification requires as on the date of the advertisement. The nature of such qualification is also specified by the NCT notification dated 23rd August 2010. The court further notices that the law is well settled on the point which stand also discussed above, that the eligibility qualification must be possessed by any candidate on the date of recruitment notification. It is undisputed that the private respondent in MAT such and such and MAT such and such acquired the minimum eligibility condition of DLED on 29th November 2022, much after the publication of the recruitment notification of 29 September 2022. In view of such the position, the board could not have created room for the private respondent. This was the observation, saying this, that Lord, the room was extended to them because and considering the first notification as a recruitment notification. This observation was not struck down by the Honorable Supreme Court and said the subsequent notification is to be read as a recruitment notification. Now, Lord,
first date of the notification, which
here, Lord, is 25/9/2025. And the second one is 19/11/2025.
okay. Yes.
Challenging the judgment and order passed by the division bench, appellant filed present appeal. We have heard Mr. P. such and such, such and such, such and such, and also Mr. such and such. And for the board, Mr. Shannal and learned senior counsel for the respondent, and then now the observation is we may mention at this very stage that we have informed all the learned counsel appearing for the persons who have filed implement a petition that we will not be entertaining these applications, but would allow them to withdraw and avail. Some candidates also wanted to join the cause, and that was the reason. Now, Lord, the interpretation, Lord, paragraph 19, Lord, in interpreting, Lord, the rule, interpretation of Rule 6.2 of the West Bengal School Teachers Recruitment Rules 2016, NCT is the statutory regulator for teachers' education. In exercise of its power under Section 32 of the NCT Act, it makes regulations specifying norms, standards, and guidelines. Inter alia prescribed minimum qualifications, and one such exercise in the prescription of minimum qualifications for teachers under notification dated 29/7/2011. The West Bengal School Teachers Recruitment Rules 2016 by itself does not prescribe a minimum educational qualification for teachers. Instead, though Rule 6 of the Recruitment Rules 2016, it incorporates the minimum qualification as prescribed by NCT norms from time to time, NCT from time to time Rule 6.2 of the Recruitment Rules 2016 is intended to be incorporate NCT qualification that is relevant as on the date of recruitment, and as such, the provision had to be worded flexibly to accommodate changes that may be brought about by the NCT from time to time. In order to ensure a seamless adoption of amendments, modification, or variations prescribed by NCT from time to time, the rule adopts the standard legislative device or simply incorporating and referring to the minimum qualification as prescribed by NCT. Further, to ensure that the latest prescription of NCT should be made applicable for any recruitment, the rule also provides that qualification prescribed by NCT prevailing as on the date of publication of the recruitment notification must be possessed by the candidate. The intendment of Rule 6.2 of the Recruitment Rules 2016 is only to declare that the qualification as prescribed by the NCT and that are prevailing on the date of publication of the recruitment notice should be possessed by the candidate. The purpose and object of this rule is not at all to declare a cut-off date for obtaining qualification. We are in complete agreement that the clear stand taken by the board in its affidavit filed before the division bench of the High Court, in which the board clarified the position as under. The aforesaid notification dated 29/7/2011 laid down the minimum qualification for a person to be eligible for appointment as a teacher. The notification never stipulates any date of eligibility. In other words, and on and from which date such eligibility is to be counted and assessed is not specified in the notification. It can be the first day of January of the year of recruitment. It can be on the date of recruitment notification, or it can be the date of which the candidates is evaluated. At the cost of proximity, it is stated that the no fixed date for consideration of the eligibility is evident from the aforesaid notification of NCT. Now, that's the affidavit given by the Lord Board before the Honorable Division Bench. Having considered the matter in detail, we are of the opinion that the High Court committed a mistake. My dear Lordship, looking at something.
Yes, read.
So that's the interpretation with regard to blood eligibility criteria of the board. Now, paragraph 21 blood is having considered the matter in detail, we are of the opinion that the High Court committed a mistake in interpreting the construing Rule 6.2 as provision prescribe some kind of cut-off date by which the minimum educational qualification must be possessed.
Yes.
This reasoning is contrary to the text of the rule. It is also contrary to the clear and unambiguous stand of the board. Board is changing terms in every recruitment process. The interpretation of Rule 6.2 adopted by the division bench is incorrect, and the judgment of this issue is hereby set aside. Now, the next paragraph would be, as I said, the all answers, the argument advised by Mr. Shannal has been answered in the Honorable Supreme Court judgment in Somen Park. That is the reason I am elaborately pressing the judgment before your Lordship. The principle, the paragraph 22, the principles as regards the date by which the candidates for selection must possess the qualification as per the precedents of this court. We must deal with the argument of Mr. Shannal, Subish Shannal and its senior counsel appearing on behalf of the respondent that as per the principle of law laid down by this court, that if the recruitment rule or the notification does not provide a date by which the minimum qualification must be possessed, the relevant date shall be last date for receipt of the application. Now, this was the submission which is I am submitting before your Lordship today. He relied on the judgment of this court in Bhupinder Pal Singh versus State of Punjab, formulating certain principles of determining the date by which candidate must possess eligible qualifications. So Mr. Shannal has also changed his stance and argued that the date of notification would be the date of last date to be treated, the eligible criteria should be treated on that. But that was not the view of the court. Neither this was the submission of Mr. Shanna. Today, Lord, for reasons known to him, Lord has changed his views, changed his Lord. The issue regarding the date by which candidates for selection must possess the minimum qualification prescribed for recruitment is no more res integra. Apart from the decision of the court of Bhupinder Pal Singh referred by Mr. Shannal, there are many other precedents which were referred to and considered in a later decision of this court in Rakesh Kumar Sharma versus State of NCT Delhi. The relevant court law has been portion has been quoted. There can be no dispute to the settled proposition of the selection process commence on the date of when applications are invited. Any person eligible on the date of submission of the application has a right to be considered against the said vacancy provided he fulfills the requisite qualifications. So these are well settled law, Lord. I need not have a trouble with Lordship. This has been reiterated, cited in many judgments, and even Lord accepted by Mr. Shanal.
Yes. The date.
Now, Lord, while dealing with this aspect, Lord, the Tej Prakash flood, which has been Pathak, has also been relied on, which has been relied on. Lord, we are all aware that the rule of game cannot be changed. But the rule, the way it is being changed by the board, is the cause we are standing before your Lordship.
Yes.
But as I said, Lord, the principle laid down in Tej Prakash Pathak, Lord, the rule of game cannot be changed in the midway. Lord, I'm not seeking any midway change. I'm saying that you please publish my result or allow me to participate or you stall the process. Because you cannot deprive. And in a piecemeal, every time, every year, every occasion, according to your sweet desire, you change your terms. That cannot be the law. Law forbids you. Law mandates you. That's an Article 15A restriction on you, that you should abide by the law of the country. You being a statutory authority, you have failed to do so.
So what does this?
Now, Prakash Pathak also, Lord, subject to the all consideration of the recent constitution decision, delivering the judgment, Justice Manoj Mishra, one of succinctly explained the legal position as follows. In various judicial pronouncements, the law governing recruitment to public service has been colloquially termed as the rule of game. The game is the process of selection and appointment. Courts have constantly frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an off-quoted legal phrase that the rule of the game must not be changed midway.
This you did not read. He has placed.
I'm not asking for even this judgment has no relevancy in my in this context because of the reason I'm not seeking any change of.
But supposing the date has not been given, then what is the proposition, settled proposition? That it will be the last date of application?
My lord. That's the judgment, Lord, that was the contention of Mr. Shanna also before the Honorable Supreme Court. That's the judgment, Lord, and subsequently, Lord. Bhupinder Pal Singh has also said, Lord, as well as Lord Rakesh Kumar Sharma has also said, Lord, that if anything is not, Lord, said anywhere, it would be the last date of submission of the forms. Now, that's the settled principle of law, Lord. Now, Lord, as I said, Lord, Tej Prakash Pathak, Lord, has no relevancy in our case because of the reason, Lord, we are not saying to change any rules. Lord, we say that you please follow the rules. We say you please publish the result. You please allow us to participate in the proceedings. We are not saying change the rules because the change of rule of game would have been if you are relaxing something for me now by way of a subsequent notification. to facilitate some other persons. If you change something, that is some, now supposedly they come and say today that, okay, there will be no interview. Only on the basis of mark sheets, marks scored by you.
Fact in Soman Pal is separate and distinct from your case, since in that case there was a separate notification which says that the person who was pursuing will be allowed.
But here also, in my case, there are two notifications, as I
The
said.
two
in September.
notifications are there, but the eligibility criteria in the notification given in the earlier, which was before the Honorable Supreme Court, in that,
Yes,
including
but-
the appearing candidates.
Lord, your Lordship would kindly appreciate one aspect. The subsequent notification is in continuation with the earlier notification. So you cannot say that ends there. That ends there. The notification is in CC. So I say, not subject Lordship kind sanction, I say the second notification is the notification for recruitment, because there your Lordship would kindly see the notification of November 19.
Yes.
Because there you invite applications. You say that you are going to one, two are distinct and different. One,
So as per your argument, it will be 9th December, which will be the last date.
obliged. That is my argument before your Lordship, that it would be the last date of submission of the forms online on that particular. That is the reason, Lord, we have come before your Lordship, that we should be declared pass or fail. Let the result be declared. So at least we will be able to understand whether I have a qualification to appear in the recruitment process. Now, you are withholding in one hand, you are saying that the last date is the date of notification. No, that cannot run concurrently. You have to take a decision that whether either you publish the result and declare me and that I have failed in the examination. So I'll not come before the court and say that kindly allow me to participate in the recruitment process. Because of you, I am not qualified. Your action is dependent on my right. That's the inaction, Lord, I have challenged in this writ application. Lord,
Which is the conclusion.
Lord, I'll just read, Lord, 3 more paragraphs, 25, 26, and 28. Because it has answered, Lord. Lord, I am on the initially, Lord, I thought, Lord, these are the factual background, Lord, I need to place. These are the, Lord, now, Lord, the Honorable Supreme Court has summarized everything and, Lord, given answer of everything. But kindly allow me to place 3 more paragraphs, Lord. The application of the interpretation and these precedent lends to the fact of the present case. We have already held that Rule 6.2 of the Recruitment Rules 2016 does not prescribe a date. Lord, this is relevant. Does not prescribe a date by which minimum qualification must be possessed. We have also upheld the stand of the board in this regard. It is in this context we must now consider the legality and validity of the recruitment notification dated 21st October 2022. We need, for a close scrutiny of the recruitment notification, is also to ensure that it is in consonance with the law laid down by this court. Paragraph 26, Lord, even as per the decisions of this court in Bhupinder Singh, the public employment must satisfy his eligibility requirement in terms of the date appointed by the relevant service note, and if there is no cutoff date appointed by the rules, then such date as may be appointed by the purpose of advertising calling for applications.
Yes.
Further, if there is no such date appointed, then eligibility criteria shall be with the reference to the last date appointed by which the applicants have to be received. Applications have to be received. Now, Lord, paragraph 28, Lord, is relevant, Lord. An important feature of this case is that the appellants were aggrieved by the inordinate delay in the conduct and completion of DLAD course for the session 2020-2022, which was to be concluded by 30th June 2022. they invoke the jurisdiction of the High Court with a prayer for immediate declaration of their result in DLAD, or in alternative, to direct the state government not to initiate the recruitment process pending declaration of their result. Lord, we are also, Lord, praying the similar relief and same relief before your Lordship, Lord.
Publish the results then. Why you are within?
Conclude your
Lord,
lordship then.
the writ petition was filed by them at the earliest occasion, that is on 28/8/2022, without any delay. Lord, here, Lord, the notification comes in September. Lord, we come approach before the court, Lord, in the month of November. The learned single judge and Lord, by this time there was a hope that yes, your result will be declared. You wait. We are talking to board the colleges. Lord, we are talking with the authority, and we have been given hope that your result will be published so that we can participate in the recruitment process. But till date, it has not been done. The learned single judge of the High Court did not take up the writ petition on merit. Had the learned judge dealt with the writ petition on merit, one of the reliefs as spread by the appellant could have been granted. That is, either that the result would have been directed to be declared immediately, or that the recruitment would have been postponed. I have also prayed for stay of the recruitment process in absence, Lord, of if they are not publishing the result of my Part 2 examination. But there I made out a case, Lord, the Honorable Supreme Court observes that either you declare the result or you stall the process, because you cannot throw me out of the zone of consideration only on the ground that you have not passed, did not get the degree certificate. Your Lordship has rightly, Lord, on the last occasion, has given an example that the students who appears in entrance examination like MBBS and NEET and JEE previously in our time, a appearing candidate was allowed to participate in the entrance examination, and if he is not passed, his qualification is his candidature will automatically be cancelled. And it is not that you are appointing me. You are allowing me, Lord. You are allowing me to participate in the recruitment process. There are processes how the recruitment would be proceeded. There are filling up of forms, scrutinizing, then, Lord, the numbering part, then there is interview, then there is aptitude test. There are many things. The process will continue and I'll miss that. What is the reason I have come before your Lordship? Because I'll miss that opportunity. For your action, I cannot miss the opportunity. The equity or right created in my favor, you cannot deprive. That's the case before your Lordship.
Yes.
Now, Lord, that the result would have been directed to be declared immediately, or the recruitment would have been postponed. Instead, the learned single judge disposed of the writ petition on the basis of a submission made on behalf of the board, proposing the equitable solution for resolution of the dispute. On the basis of the submission of the board, the High Court permitted candidates such as the appellants to be given an opportunity to participate in the recruitment process. The learned judge of the High Court was not compromising on the standard prescribed by the appointment. It is nobody's case that unqualified persons will be appointed. The direction of the learned single judge enabled candidates as such the appellants who were at the stage of completing the course to participate in the selection process, and they would have been appointed only upon attaining the prescribed qualification. Well, Lord, I qualify. Lord, I'll be appointed if I qualify the thing. If I am competent and if I am scoring and coming with the zone of consideration for appointment. The appellants who applied as per the recruitment notification dated 21/10/2022 obtained their course completion certificate on 29/11/2022, and their final results were declared on 30th December 2022 after the recruitment notification. The interview commenced in December 2022. And when the process was to be taken to its logical end, the division bench passed the impugned order, setting aside the direction of the learned single judge by interpreting the 6(2) of the recruitment rules 2016 as if it prescribed a cut-off date for eligibility. And ultimately, Lord, The facts of the case reveals a rather extraordinary situation where the board and also the High Court ought to resolve the problem that had arisen due to late conduct of the B.Ed and DLAD examination immediately after the COVID-19 pandemic. We are of the opinion that there is no illegality and arbitrariness in the actual recruitment notification dated 21/10 of the subsequent notification, and the recruitment process commenced under the relevant rules and also as per the direction of the learned single judge of the High Court disposing of the writ petition. It is important to note the recruitment notification dated such and such was not challenged by anyone. And Lord, the Honorable Supreme Court, Lord, reiterates, Lord, the eligibility qualification on the date of the last date, Lord. And in this way, Lord, the earlier recruitment process of 2022 was affirmed by the Honorable Supreme Court. Lord, the issue was said. The genesis and the originating part was, Lord, of non-publishing of the result of the DLED candidates. They were given, Lord, the board consented in the earlier recruitment process that yes, we'll allow them, even pursuing candidates. Lord, here to Lord, we have completed the course. In the earlier occasion, they have allowed the pursuing candidate also, part 1 only. Part 2 examination was also not done. So I say, Lord, before your Lordship, that the earlier occasion also, Lord, this question traveled to, Lord, pertaining to the same recruitment process. And your Lordship has seen the observations made by the Honorable Division Bench as well as the Honorable Supreme Court, how the rules of Rule 6.2 has been interpreted, and how the candidates whose result has been withheld, has been accommodated and allowed to participate in the recruitment process. Now, Lord, it was obviously the Honorable Supreme Court has held, Lord, while deciding the issue whether their participation was legal or illegal, has also said the option before the Honorable Single Judge was either directing them to publish the result or to stall the entire selection process. Because as I said, Lord, I have made out a case by this time before your Lordship that I have completed the course. You are not doing it. You are obligated to complete it by June 31st. We are in December already, 6 months has changed. If you take, Lord, the words of Mr. Shannal, that 7 months, we are already in 7 months. And on previous occasions, Lord, also, Lord, there are other recruitment, Lord, examinations of DLAD, Lord, they have passed, Lord, they have published results in the month of first week of December also. Lord, this action of withholding result, Lord, is an act of arbitrariness for which, Lord, we have been disallowed to participate in the recruitment process. Lord, the Honorable Supreme Court has ultimately discussing everything, Lord, has upheld the order of the Honorable Single Bench and set aside the order of the Honorable Division Bench.
But taking in consideration Bhupinder Pal Singh, Rakesh Sharma and Tej Prakash, it holds that the qualification must be possessed as per those prescribed in the rules.
Now, Lord, the rules, Lord, your Lordship, that's the reason, Lord, I need to, your Lordship would kindly take, Lord, paragraph 29 once for a second.
Now, 6.2 says that it should be possessed on the date of advertisement.
But that has wrongly been interpreted, Lord. Your Lordship would kindly take, Lord. Now, Lord, it has to be read with, Lord, paragraph 21 also, Lord.
Paragraph 29.
29 and 21. Let me change, Lord.
How do you interpret this? Suppose qualification must be possessed as per those prescribed in the rules. Rule says on the date of advertisement. Then it says or the notification. Rules or notification. And in absence of both, if the rules is silent, the notification is also silent on which date it is to be possessed, then we go by reference to the last date appointed for receiving it.
Now, my lord, here in that case also, my lord, the final result was published in the month of December. That was also taken into consideration, and they were allowed to participate in the recruitment process. That is what, my lord, my contention is.
But the proposition, do you find that in the facts and circumstances of this case,
My lord.
if 6.2 says that on the date of advertisement,
My lord.
accept your analogy that the date of application will be November 19th, November 2025, which is the subsequent application which says that the last date would be 9th December.
My lord.
So in continuation to that, the second has come. In
Yes.
the month of November also, they are not possessing that. But six to says that it will be possessed on the date of advertisement. And after considering Bhupender Pal Singh, Rakesh Kumar and Tej Prakash, the court says that in the absence, the rule is silent, the notification is silent of the date on which the candidate must possess the degree. In that event, the last date fixed for receiving the applications will be the cutoff date on which the applicant has to possess that degree. So, how do you interpret this?
My lord.
Because that's why I told you the facts here is they have completed 2 years course. The results are awaited. In the earlier one, they allowed part 1 who has completed part 1 to participate in the process. Correct. So starkly there is a difference in the facts of the earlier case and this case.
I understand. Lord, I am on a better footing than of them.
Correct.
Because of the reason that
Your only lacking is that the results have not come out.
Mala.
Well, so far as the date of concerned, that date has been in 6.2, it has been stated that it should be as per the advertisement, date of advertisement.
No, my lord, your lordship would
And the
kindly
court also says that if it is absent, then we can take that date. That the last date of receiving application can be applied in your case.
No, my lord, your lordship would kindly take, Lord, note of Lord, which has been placed in paragraph 3.
No. Mr. Sonnally placed that.
May
Yes.
Paragraph 20 has your lordship is looking at 6.2. That is also quoted in the judgment. আগে recruitment notification টা দেখাচ্ছি.
When did
I just
6.2 has been amended on which date?
December 2020. 22nd December 2020.
ডেটটা আমি বলতে পারছি না।
হ্যাঁ,
22nd December 2020.
But the rule 6 which has been quoted and the rules which has been given here, both are separate. I find the language.
Yes, unamended, amended.
Which one?
In the judgment of the Honorable Supreme
Paragraph-
Court, so many.
Paragraph
Yes,
3.
yes, paragraph 3.
The candidate shall possess the minimum educational and training qualification as prescribed by the National Council for the Teachers Eligibility Education
As on the date
prevailing
of
as on the date of
Yes, yes,
publication
sir.
of the recruitment notification. It's there. That has been interpreted. That was my case, Lord. I have said that has been taken care of. Now, Lord, I will just, Lord, show the earlier notification. That is at page 624 of my writ application.
But what about 31?
I'll come. That is
Paragraph 31, just I have indicated.
the cutoff.
What about 31?
Your Lordship would kindly take note of the earlier notification for a second. Kindly. Page 624. আর যাবো না
ছেড়ে দে ক্রিমিনাল বেল দিয়ে কিছু হবে না দেখেছিস রিটে সবচেয়ে পয়সা বেশি সিভিল
Your Lordship would kindly see the earlier notification, Lord. What is the Lord? Well, 3B. Your Lordship would kindly take.
How will it better your case?
My lord.
You just tell me what should be the date now. Yeah, the judgment which you have referred, this concluding portion.
Your Lordship would kindly take note of 624 3B.
Unamended is there.
This is both.
Same, Lord. This is same.
না ওইটা একটু আরো অন্য
Rules টা কথা বলছি rules এ Lord, that particular was not there.
Your Lordship will find page 117 of the spiral. This was rules of 2016. March 2, 2016. Qualification 6-2.
Candle yes. He is referring to 3. So, Ahmed, you are referring to?
Lord, 624 3B. The candidate shall possess the minimum educational and training qualifications as prescribed by the National Council for Teacher Education prevailing as on the date of publication of the recruitment notification. That was the first notification, Lord, which the Honorable Supreme Court has taken note. There subsequently, Lord, in 21st October, and says, the Honorable Supreme Court says, since there is a publication and disclosure of vacancies and mode and modality has been set, so that is the recruitment notice. Now, Lord, we need to read, Lord, along with this paragraph 21 for a second. The Honorable Division Bench, Lord, held otherwise, but the Honorable this has been discarded by the Honorable Supreme Court. Having considered the matter in detail, we are of the opinion that the High Court committed a mistake in interpreting and construing Rule 6.2 as a provision prescribing some kind of a cut-off date by which time the minimum educational qualification must be possessed. This reasoning is contrary to the text of the rule. It is also contrary to the clear and unambiguous stand of the board. The interpretation of Rule 6.2 adopted by the division bench is incorrect, and the judgment on this issue is hereby set aside. Because the previous paragraph Lord have placed is Lord, the previous paragraph Lord I have shown Lord is the notification of the NCT, and they are Lord, I'm sorry, Lord, the affidavit Lord filed by the board.
প্রবলেম বলতে সুপ্রিম কোর্টের জাজমেন্টকে হাইকোর্ট মেনে নিতে পারে তো সুপ্রিম বলে মানতে হয় সুপ্রিম কোর্ট ভুল দিলেও সুপ্রিম বুঝতে দেওয়াটা প্রবলেম না প্রবলেমটা অন্য জায়গায় লটা
Otherwise, you are celebrating. This notification of 29/9/2020 is akin to September notification. কিছু বলার আছে?
You have given a copy to Mr. Sannal?
The judgment, Mr. Shanal appeared.
Might
I'm
be, he
giving-
has appeared in many cases. Give him. Page 21 of the judgment.
নিচে নাম্বার।
So if you start with page 20, then it will be clear. Now the intendment of rule 6.2
Just
is,
a minute, Honor.
yes,
Hmm.
is to declare that the qualifications as prescribed by NCT and are prevailing on the date of publication of recruitment notification should be possessed by the candidate. Now the purpose and object of the rule is not at all to declare a cut-off date for obtaining the qualification. Now, what was the affidavit and what was the declaration before the Honorable Supreme Court by the board regarding certain interpretation of the date of publication?
Date of
Publication. It has been set out.
Done. Lord, your lordship's quoted portion.
Yes,
Lord, may I read out with your lordship?
yes.
The aforesaid notification dated 29th July 2021 lays down the minimum qualifications for a person to be eligible for appointment as a teacher. The notification never stipulates any date of eligibility. Lord, this is, my lord, pause here for a moment. This is the notification of NCT. NCT is not the recruiting authority. NCT is the academic authority under the Right to Education Act. His job or exercise is only to lay down the qualification, minimum qualification, nothing else. How can he prescribe the date? Can he prescribe the date?
That is what the
That,
Honorable
Malad,
Court is
with
saying.
all respect, Malad, may I tell your lawsuits? Judgment of the Supreme Court is the supreme. We have to abide by that. But your lawsuits in the facts of the case, whether this judgment goes, I will make my submissions, your lawsuits.
No, Lord, I know, Lord, like previous occasion, Mr. Shanal said that I have not said anything about it. Again, he will come and say, no, this is the first notification and we should be abide by the, we will stick to
Don't
the
presume my
September
submission.
notification.
So you conclude
No,
your
I,
argument.
because of the reason, Lord, I failed one bus, but I do not want to.
বাস ফেল করেছি।
আগের বার টেটটা না বললাম না, আপনি এসে এমন বলে দিলেন যে আমাকে এতক্ষণ ধরে এক্সপ্লেনেশন দিতে হচ্ছে। দ্যাটস দ্য থিং, Lord. না, Lord, this is
দিচ্ছি তোকে দিলাম।
সেটি learn from you, Lord. This is in respect of. হ্যাঁ
কালকে কোথায় ঠিক তো তারিখ তো
আরো কিছু বলার থাকলে
অবভিয়াসলি আরো 3টে পয়েন্ট বলার হবে।
সেকেন্ডটা তো বলবি?
আর সেকেন্ড
প্লিজ আমাকে
সেকেন্ড
বল, আমি কালকে আসতে পারবো না। না তুই তবে তবে শামীম বলবে, বলিস না, আমি পারবো না, তাহলে আমি সোমবারে ফিক্স করবো। হ্যাঁ সোমবারে করে দেন ভাই,
স্টেট আছে
মুশকিল হয়ে যাবে আমার পক্ষে, শুনে ভোট যাবে আমার পক্ষে মুশকিল হয়ে যাবে। আমি শুনে নিয়ে তারপরে তোর বল না, তারপর যা খুশি আমার পাঠাতে বলে আরে ঘরে ঢুকলাম মানে এই মামলাটার জন্য। আমারটা অপোজ করবে ও এখন কি করবো, ওরটা অপোজ তো রাখ।
No, Lord,
কালকে আসতে পারবো না।
in answer
এই ডেটটা ভুল হয়ে গেল বুঝলে।
in answering, Lord,
জাস্ট মিনিট মিস্টার ইয়েস
শীতকালে পড়া যায়। Now, Lord, so far, Lord, the other issues, Lord, these are the with regard to, Lord, I have made my submissions with regard to, Lord, date and, Lord, the cut-off date and, Lord, the parity with regard to the earlier recruitment notification and the consequence, Lord, ended up to Supreme Court. And I say, Lord, I may be looked into in that perspective that there cannot be any cut-off date for qualification. And it will be on the last date of recruitment notification. The recruitment notification is to be considered as, Lord, the 19th November 2025. And the other point, Lord, which has been raised by my senior friend is that, Lord, some of the applicants here in the writ petition is party, Lord, in a different writ petition. Lord, I completely, Lord, bow down before your Lordship, Lord, that the prayers with regard to, Lord, the relief, Lord, sought in that writ petition and this writ petition are two distinctive cause of action. The cause of action in respect of that particular writ petition is otherwise, and here is the immediate cause that the recruitment notification has been published, and we will be thrown out of the jurisdiction since our result has not been declared. So, Lord, there is no reason that all the same cause of action, Lord, we have come before the court.
But what is the prayer in the earlier writ?
The prayer in the writ petition, Lord, and here, may I just read, Lord, the prayer of the writ petition, Lord, on the last occasion, Mr. Vishwas has handed over to your Lordship, Lord. Lord, that was, Lord, the prayer, Lord, the entire writ petition and the pleadings, Lord, when the writ petition was for the purpose of uploading the data, for the purpose of automatic filling up of forms, because the West Bengal Primary Board maintains a data in respect of individual candidates, like when he has passed TET, when he has, what is the score, what is his name, what is his address. Now, Lord, that was for Lord. আচ্ছা আচ্ছা তুই জেরক্স করে দিলি
না জেরক্সটা দিয়েছে কিনা আমি জানি না
So that was, Lord, for the purpose of, Lord, the prayer was for uploading those datas, the DLAD degree data, TET data and everything, Lord, so that, Lord, nowadays what happens, now the moment, Lord, I put my, Lord, mobile number or my name, it automatically, Lord, like the way it automatically in Google form, Lord, the moment we say autofills, Lord, comes, this is the way the board maintains a data. Lord, I can place, Lord, the pleadings in the writ petition. Lord, I'll just, Lord, read paragraph 3, Lord, while the jural relationship has been explained, and then paragraph 3, Lord, speaks about, Lord, the jural relationship, and then, Lord, paragraph 4, the writ petitioner states that the West Bengal Board of Primary Education published a notification on 29/9/2022 for conduction of, Lord, TET and such and such. In that said notification, it is clearly stated that only those persons who have acquired the academic and professional qualifications specified in such and such, also with such and such, it is also stated in that the candidates who have required minimum academic qualifications after the date of publication of the notification will not be entertained for appearing in TET and such. Now, Lord, then paragraph 5 says, Lord, we say that we are eligible and appeared, and then paragraph 5 says the petitioner said the petitioner have all requisite qualification had requisite qualification to appear in TET 2022 examination conducted by the such and such board. All the petitioners have B.Ed degree, and at present all the petitioners are pursuing candidates of DLED session 2023-2025. All the petitioners have all requisite qualification to appear in TET 2022 examination and qualify in the said examination. All the petitioner possess the eligibility criteria of B.Ed as per advertisement notification, and they are eligible candidates. All the petitioner, but basically this was the effect plot sought in terms of the judgment delivered in Devesh Kumar. And your lordship would kindly Devesh Sharma. At Devesh Kumar judgment sanction
CF.
The paragraph.
Prayer F. Prayer F.
Declaration of TET. That has been pointed out by Mr. Shannar. Declaration declaring that the petitioner all are eligible TET 2022 past candidate to participate. Lord, your lordship would kindly take note to participate in any future selection process. That is what we are seeking, because of the reason, Lord, we have qualified to the extent of DLAD degree.
No, in the present writ petition, you say that you have qualified TET only because the results in DLED has not been declared, so that be published so that they can participate. The other writ petition, you seek that you be declared as a valid candidate TET 22. The person who seeks for declaration, he or she himself is not clear whether it is a valid TET 2022 or not. So there was no purpose for the petitioners, as he has indicated, that to seek for a declaration of TET 2022 when he himself knows that he has qualified.
Lord,
What was
this
the
is-
purpose of
this is-
seeking a declaration from the
Lord,
court?
seeking, Lord, because by this time, Lord, your Lordship would kindly see the date. By this time, Lord, there were 2 writ petitions pending. There are, Lord, the board himself, Lord, has issued a notification, which Mr. Sannal has, Lord, referred. So, Lord, we sought, Lord, a declaration from the court, which is also, Lord, integrated, Lord, issue before your Lordship also. So, Lord, the question of
Along these candidates, for the sake of argument, will make the earlier writ petition where a direction has been issued for filing affidavits by the board.
along with other reliefs, Lord. This
What
was
are-
the
what will be
primary
the
writ
fate
petition.
of this writ petition, the earlier one?
The earlier one, Lord, was, well, kindly give me a second. Mr. Shamim appeared in that writ petition.
I give the
আমাকে বলে নে।
রিপোর্ট ফাইল করেছিল সেখানে বলেছে they are eligible.
Okay, my point was suppression. Your losses need not go into this.
No, Lord,
By prayer is a suppression.
no, Lord, I say,
One
Lord,
for
subject lordship can sanction.
disclosing.
The cause of actions are different because they are, Lord, we are only seeking, Lord, only seeking, Lord, uploading of documents.
So the same prayers are coming over here.
No, it's not, Lord, the prayers are different. Lord, I'll just read paragraph 10, Lord. The petitioner states that the West
Mr.
Bengal board.
Ahmed, the couching of the language is different. In that case, you said of uploading, your prayer is for publishing. Until and until the results are published, there is no question of uploading.
Not result. The earlier writ petition was not declaration of result. That was only for the purpose of, Lord, uploading, Lord, informations in the website. Lord, may I just, Lord, read it. Your petitioner states that the West Bengal Board of Primary Education on 4/11/2022 published a notification for online application of teacher eligibility, wherein inter alia stated as follows. Now, Lord, we have said certain things, and then, Lord, we prayed for, on the day the petitioners are, Lord, we declare that we are eligible candidate, Lord, in TET. We do not say, but on the declaration, we wanted to participate in the selection future process. Now, the Lord, this is first stage. Lord, kindly allow me to clarify. The first stage is that you allow me. Now the selection process has started. Now I come and say, you allow me to join. Because that was, Lord, a preparatory, Lord, writ application because their data were not available in the website. And the main issue, Lord, we Lordship would kindly take note of it. The initial issue was the TET was with B.Ed. Now, this writ petitioners wanted to incorporate their DLED degree in the database. That was the writ petition. The purpose was, Lord, a preparation to upload the document with the board so that we can take participate. Your Lordship, if your Lordship sees paragraph prayer F, the paragraph prayer F is to declare TET to participate. Because
a copy of that.
But
That's all.
Lord, when we go to, Lord, fill up the forms, Lord, when you put, as I said, Lord, I just stopped. When you fill our name, number, or, Lord, other data, automatically it takes from the database of the, Lord, board. It is autofill, so that, Lord, nobody can tamper and no individual. Photographs also comes.
Yes.
It's not that, Lord, the entire thing is autofill. The moment the code is or TET number is given. So for that reason, Lord, we wanted to upload our degree with regard to DLED. Lord, why this is being done? Because the earlier notification of 18 June, Lord, notification is all about that if a candidate is, Lord, allowed to participate in the recruitment process, he has to undergo a bridge course. Now we do not require a bridge course because already we are having a DLED degree. That we wanted to include. That was the purpose of the writ petition.
No, DLED, you are not, right now you are not possessing it. You have completed.
The database is not taking. So, Lord, we also wanted to inform. Sir, আপনি দুদিন ধরে বোঝালেন। Yes, that is Lord, may I just read the first prayer, Lord? Your Lordship would kindly see, Lord.
Okay,
First
I will
prayer.
see your prayer and tally with the present writ petition.
My Lord. The first pair is, my lord,
You say that your earlier writ petition was in anticipation that in future recruitment you will be allowed
obliged.
to have a blanket order that in future if any recruitment
Deeply
process is taken, in the meantime a recruitment process is taken up, so you come with the
Deep
subsequent.
obliged, not
This is your case.
That's the blood purpose.
Okay.
Because the prayer says alter teacher training data of the petitioner in West Bengal, such and such.
That's all.
Malad, yes. These are the things, Lord. I just missed one point. One point because of the reason, Lord.
আমি বলিনি যে তারপর
The recruitment notice is concerned. The recruitment notice is concerned. I'll accompany, sir. The recruitment notice is concerned. The new batch of candidates wanted to move the writ petition before this honorable court, challenging, Lord, the notification of 20 September 25. The board comes and says, no. I'll just read. The learned counsel appearing for the respondent primary board has rightly pointed out to the court that the notification dated 25/9/2025, on the basis of which the petitioner's pray for liberty is not a notice calling for application. Clause 9 of the said notification is relevant, wherein it has been stated that the schedule for opening application portal and submitting the filled in application form through online mode will be notified later. So they cannot come and say that this both. So Lord, they cannot come and say that this is a recruitment notification. Lord, this is the observation, and based on the submission, the writ petition was dismissed. So, Lord, in all probabilities, Lord, the petitioners before your lordship being, Lord, the candidates who have completed their DLED degree, Lord, they cannot be deprived of to appear in the recruitment process.
very next matter is
Respect to item number,
very next
Lord,
matter
with
is
respect
mine.
to item number 211. My lord, only thing, my lord, before hearing the board or the added parties, we are also sailing on the same boat. My lord, let us complete our argument.
Otherwise,
Thereafter, it will be a combined reply. Otherwise, it will continue.
my lord, otherwise, my lord, we will be prejudiced, my lord. Kindly, but otherwise, my lord, we will be prejudiced, my lord.
Your
If
lordship,
it is
remember, kindly,
decided,
we will not take, my lord, more than 10 minutes,
I
my
will
lord.
take, my lord, just 5 minutes.
Last but not the least, Lord, I've missed one point. Lord, your lordship, Lord, I've gathered, Lord, your lordship has already allowed, Lord, the
Pursuing
special educators, the pursuing candidates. Lord, that order, Lord, I'm not.
That is separate. That
My lord, I think, my lord, after recess, my lord, I will resume.
My lord, only thing, let us start,
Just
my
to
lord,
reply,
because
because-
otherwise, without hearing us, there is no point. We are also sailing on the same boat, little different. We are not TET 2022. We are TET 2023. We appeared in TET as a pursuing candidate. We qualified TET. Now, immediate. My lord, this is the
Kindly
fact,
let us
my lord.
dispose it of fast.
My lord, if
This
that
is
is
why, my lord,
disposed of, my lord,
required
our matter will be prejudiced, my lord. My lord,
that
kindly hear me,
place
because
our
Mr. Sannal,
thereafter, David.
my lord, Mr. Sannal swing in both ways.
Mr. Ghosh has no cause of action.
Mr. Sannal sometimes appeared in behalf of the petitioner to take their side, like they take us, the petitioner to protect their right. The board is selling to protect Mr. Sannal's personal client right. I will show it from the order itself. Yes.
Personally, my lord.
No. I report. I will show the board order, my lord. I will show it. I will show it. I will show it. I will show it, my lord. My lord.
Most clients,
Yes.
they are eligible, they are appearing.
Because of that, they wants to protect someone's right. They wants to restrict the selection process to some of the candidates, my lord. They wants to reduce it. That's the point, my lord. Our endeavor is that, my lord. Because of that, my lord, what is the matter about? But this matter about that, my lord, board ought to, my lord, board ought to publish the result. Why they not published it? Because of that, my lord, they delays this 6 months to accommodate those candidates who are their favorite candidates. I will show from that order, my lord, itself, my lord. Yes, my lord, kindly give that, my lord. Otherwise, they want, my lord, they come with that, this matter, my lord. They want that only one matter, not that, my lord. Our right will be infringed, my lord. I will place it, my lord. Thereafter, my lord, pass the order.
My lord, we will hear it at, your lordship kindly hear me for 10 minutes. I will adopt Mr. Ahmed's submission. Only I will add three additional points. Thereafter, my lord, I will not take much time. I will adopt primarily Mr. Ahmed's submission. Will only take
the date to 2025 pass.
2023, not 2025.
Is it the same 2022 date pass? But who are they? I have challenged the candidature since they are the date qualified.
Here be at least 10 minutes, thereafter, course.
I will demonstrate your lordship. My senior is there. I will demonstrate your lordship. They are not even pursuing when the date was conducted. So the matter and the consolation are different. So the reason are different.
This matter is all about the pursuing that candidate who completed their course, my lord. Till date, the board not, because the board conduct the selection process, board conduct the DLED, and board conduct the TET. The same authority conduct it, my lord. So, my lord, they consciously delayed it, my lord. I will show it, my lord. They consciously delayed it to restrict this selection process to some of their favorite candidates, my lord. That's the point.
This would be an unending process, Lord, if people.
Do not be, my lord, if they publish it today, what is the impediment to publish the result today? Because the result, that is not their business. They were the addition of party. They want to reduce the competition. That's their endeavor. What is that? And for board work in their benefit, to reduce their benefit. In June 2025, the course is complete. The NCT guideline and a notification is very specific. Course is 2 years. The student can do it for 3 years, my lord. It is student prerogative, not the authority's prerogative. Authority now extended that time to accommodate their favorite candidate. That is their purpose. Do not publish the result, my lord. That is their whole purpose. That is their whole purpose, my lord.
Thing is before the court. Now let me come back.
Yes, my lord. My lord, kindly hear us. My lord, kindly hear us, my lord. I will demonstrate from the court record itself.
My humble request, your lordships, kindly hear me first. Let them hear all.
How will we place our
I will not come back to argue again.
My lord,
Let them place thereafter if your lordship so desires. But my humble submission is a independent writ petition decide on its merit. If there are different facts,
My lord, board can't say so, my lord. Board can't say so. I believe Mr. Shanlas, my lord, they appear on behalf of the Article 12 authority, not on behalf of the private party, my lord. They act, the board work in the instances of a private party.
why? How?
Well, my rights is infringed, my lord. For board, everyone is similar.
What is your difficulty if your matter is taken up separately?
My lord, difficulty is if the order passed, my lord. If the order passed, it will
If the court asks you to argue your case separately and Mr. Sannal to reply separately, what is it?
then I have no.
Then my lord,
What is the difficulty?
that's the my point, my lord.
My lord,
Kindly hear us.
that is what is followed.
Wait,
What order?
My lord, that is
Bow
what
down,
falling
my lord.
from your lordship, that your lordship will hear it separately. and
Yes,
Mr.
yes.
Shanna,
You make
I-
it
I-
separate.
we have
Let me
problem.
come with it separate.
That's my
Tomorrow,
submission.
Then to any date, my lord.
At 10:30, my lord, Mr. Mujumdar is leading me. That item 211. My lord, I have
Mine is the 215, my lord. Then my lord 10:30, my lord. Tomorrow.
না না আজকে আর তাহলে কালকেই হোক, ঠিক আছে না 211 and 200.
But tomorrow I will not be available, my lord.
Okay, my lord,
for my
one day
personal
you
business.
give reply.
Let them conclude it. I will give the reply.
But make it short, huh? For 3 days, I am hearing this. Mr. Ahmed first started, then he made his submissions. After that, again, today, Mr. Ahmed has. If this continues, then we'll cross the limits.
My lord, that
Ah.
is why, my lord, we are saying.
What you
after
do
recess,
is, since one matter has been heard, you were in court, you place your case separately. What are your points? Let Mr. Sannal reply to that, as well as if any other party is there.
Yes, my
Yes,
The
yes.
respondents will make their reply.
Then
pass you.
tomorrow at
Correct.
That's
Tomorrow, Mr. Sannal, in respect of this, you will continue in second half.
no, second now. And I will finish, my lord, as soon as possible.
Okay.
Then, my lord, next
Because your
time
lordship has dealt with
211
elaborately all that
tomorrow,
order.
give our points.
211 and 215 tomorrow.
Tomorrow.
Fine. 10:30, my lord, kindly. Otherwise,
আরে
it
বা
will
করুক
again.
না ওদের মামলা, ওরা বলতে ক্ষতি কি? পরে আমি বলে
Which
দেব।
one?
211 and 215, 10:30 tomorrow.
Okay.
দাদা এটা শুনে নিলেন ডিপলি
211.
তাই তো
हाँ
2015. Okay.
Deeply obliged.
পানিশমেন্ট কিন্তু 7 বছর।
এটা তো বাড়িয়ে দিতে হবে 70 বছর।
No,
No, my lord, I'll be very, very concise. I find your lordships is being disturbed by us to an extent.
no, no, no.
Certainly, your
Not
lordship.
like
I bow down to your patience, your lordship's patience. Only thing I just your lordships. Your lordship has heard me yesterday, today at length. Now, my learned friend, second point, both are eligibility point, B.Ed and pursuing. According to me, both are point of eligibility.
yes.
But if your lordships takes up the first point, B.Ed, and suppose your lordships views in my favor, your lordship need not go into the second point. This is my submission. But if your lordship is against me on the first point, certainly your lordship has to take the second point, because that's also we have raised. Now, my lord, Devesh Sharma's judgment, I placed it, but not your lordships to the extent, because only the ratio I placed. Now, before that, your lordships, my learned friend has cited Suraj Kumar Okram. I have to distinguish it. And with the proposition of law. Now, my lord, again I repeat, whatever judgment your lordship cited in this Okram, I'm sorry, my lord, Suraj Kumar Okram, your lordships will find in so many languages Supreme Court says, any act or notification or law, if declared unconstitutional today, it will have retrospective effect from that date. My lord, here your lordships will find this, Mr. My lord, I just take the name personally, Dr. Rajiv Dhawan. Your lordships will find one of the senior counsel appeared in this matter, page 727. Why I'm telling you, lordships, the doctrine of prospective overruling, though first came your lordships in the judgment of the celebrated judgment in your law college, Goloknath, but your lordships, this particular celebrated lawyer took up this point in a revenue matter, doctrine of prospective overruling. What happened in that matter, just I tell you, lordships, then I will take. Under the revenue law, central government collected huge money. Now, my lord, that was being argued by Mr. Noriman, no less than a person Noriman. Now, Noriman succeeded. Judgment delivered. And after the judgment delivered, the my lord, Dr. Rajiv Dhawan jumped up. He was appearing for the Union of India. My lord, I have one submission. Bench was against him. No, we have delivered your judgment. Unconstitutional, the consequence will follow. No, my lord, government has collected huge sum of money and invested it in public purpose, expended it in public purpose. What will happen to that? Government, how can they refund the money? Then, my lord, in this sort of matter, the my lord, Supreme Court applied the doctrine of prospective overruling to save the government, save the public money. My lord, that prospective overruling cannot be applied everywhere and anywhere. And that's why the Supreme Court in Devesh Sharma, it's limited to those candidates who got the benefit of appointment, because otherwise they will lose the bread and butter. And clarified that, except those candidates, even who have selected but not appointed, he will also not get them. Far less to speak of who has participated, all that. Now, this is your lordships, the point of eligibility. A person with B.Ed qualifications cannot say that I am the qualified, because Supreme Court says B.Ed is not a qualification. Kindly visualize the rule of it. Whatever judgment your lordships, if your lordships today declare the B.Ed, but allow them to take as B.Ed, then your lordships would be allowing B.Ed as a valid qualification for primary recruitment. That's my submission. That cannot be done. A person ineligible to teach a particular class, he cannot be declared to be valid. That's the basic point, your lordships. Whatever judgment Supreme Court says. Now your lordships will find this Suraj Kumar Okram. I take your lordships only the paragraph, not anything. Now your lordships will find here 2012 4 Act, 2000 by 12 Act was repealed by Act of 2018. But in the repealing Act, there is a saving clause. Each slight difference in fact, your lordship, makes the entire judgment inapplicable. That's the Supreme Court's view. Here, your lordship, there is no saving clause. But even that, my lord, kindly consider paragraph 5. These petitioners contended before the High Court of Manipur that the Manipur legislature lacked competency to promulgate the 2012 Act. It was further submitted before the High Court that the saving clause in the repealing Act of 2018 is a devious method to justify illegal appointments made by the virtue of the 2012 Act. So this was the bone of contention, issue before the lawsuits, least before the Supreme Court. Now your lawsuits will find paragraph 23, page 734.
Yes.
It is a settled legal proposition that whenever an act is repealed, it must be considered as if it had never existed.
Kindly paragraph number.
Paragraph 23. Page 734.
State of UP versus
State of UP versus Hirendra Pal Singh. The court was of the following opinion. Then paragraph 22 quoted. It is a settled legal proposition. Whenever an act is repealed, it must be considered as if it had never existed. The object of repeal is to obliterate the act from the statute books, except for certain purposes as provided under Section 6 of the General Causes Act 1897. A repeal is not a matter of mere form, but is of substance. Therefore, on a repeal, the earlier provisions stands obliterated from the statute book. This was, my lord, Supreme Court considered in case of repeal of the act. Then your losses, kindly see paragraph 25. The crucial point arises next for our consideration is the validity of the saving clause in the repealing Act 2018. Then you will see paragraph 27. What I am trying to submit before lawsuits. When a statute is adjudged to be unconstitutional, it is as if it had never been. Pause here for a moment. 2018 notification allowing B.A. Devesh Sharma declared unconstitutional. First judgment. I will make submissions online review. So as soon as this is unconstitutional, it goes from the statute book or from the notification book, from the date of the notification. There cannot be any quad. Being a student of law, we can't do that. We have been taught that, my lord, we cannot play with the court with the facts, but we can play with the court with the law. This is our, because we can develop the facts, we can never play as a lawyer. Rights cannot be. Rights cannot be built up under it. Each word is different. What's they are now asking for right? I am TET pass on the basis of BA. Can it be built up? It cannot be built up. Unless the Supreme Court saves it. Contracts which depend upon it for their consideration are void. It constitutes a protection to no one who has acted under it, and no one can be punished for having refused obedience to it before the decision was made. Yes. This is the judgment, your lordships, of fully on constitutional limitations. Kindly see that each word is so nicely written. Now, pause here for a moment. More so, we put them on notice. My learned friend has said, subject to Devesh Kumar is in their favor. How can it be, I failed to understand? On point of law. It's not fact. Therefore, your lordships, 27, then 28. An unconstitutional law, be it either due to legislative competency or in violation of fundamental rights guaranteed under Part 3, is void ab initio. This was declared invalid, being obited, and unconstitutional. It's void ab initio. How can one get the right derived from it? One cannot derive any right from it. Whatever may be the consequences, my lord. Then, your lordship, my lord, your lordships, paragraph 33. I think, your lordships, this paragraph 33, I need not. Your lordships, doctrine of prospective overruling for the first time applied in Golokna. And when applied, your lordships, for that. Paragraph 52 quoted. The doctrine of prospective can be invoked only in matters arising under our constitution. Then next, your lordships, with all respect to the bench of this court, kindly have a look at this. Paragraph 2, because I will be making submissions on this. It can be applied only by the highest court of the country. Now the high court cannot. Prospective overruling cannot be applied by the other high courts, except by the Supreme Court. That is to say, the Supreme Court, as it has the constitutional jurisdiction to declare law binding on all the courts in India. Now, why I am saying it consciously, kindly see the review judgment. Supreme Court restricted prospective overruling only for the appointments made already, none else. How can it be extended or horizontally applied? Supreme Court made it vertical only to those candidates. It cannot be applied horizontally now. They cannot make any prayer before your lordships. Then, your lordships, the core scope of the retroactive operation of law declared by the Supreme Court, superseding in its earlier decision, is left to its discretion to be molded in accordance with the justice of the cause or matter before it. That's a different aspect. Supreme Court, in appropriate case, can mold it. Then, your lordships, again this power of the Supreme Court. Now, your lordships, I am straightway to the paragraph 39. Kindly, what deduced by the Honorable Supreme Court. The principles that can be deduced from the law laid down by this court, as referred to above, are: a statute which is made by the competent legislature is valid till it is declared unconstitutional by a court of law. Everybody has to follow it. But as soon as it is declared unconstitutional by the Supreme Court, it goes from the statute book from the date it was made.
Yes.
Then, your lordships, 39.2. After declaration of a statute as unconstitutional by a court of law, it is non-est for all purposes. These are corollary consequences. Supreme Court says, so long I do not make it unconstitutional, it's valid. But if I make it unconstitutional, for all purposes is good. From the date it was declared. From the date this was made the law. Then, your lordships, 39.3. In declaration of the law, the doctrine of prospective overruling can be applied by this court to save past transaction. Past transaction means whatever happened inter regum. Yes. Under earlier decisions superseded or statutes held unconstitutional. What have the present petitioners done, your lordships? They have got their TET qualification with B.Ed on the basis of 2018 notification. With the rider of the board, please look, you are appearing subject to the Supreme Court. Made it clear. Now, this is not a matter of joke that I give them put on notice. Why? You then ought to have went before the Supreme, ought to have gone before the Supreme Court. Save me also. They have not. That's not the judgment of the Supreme Court. They appeared with this rider. Now they cannot come up before a lawsuit and make submissions on that, because it's only the jurisdiction of the Supreme Court. Then, kindly see 39.4. Relief can be molded by this court. Repeatedly, Supreme Court says by this court, in exercise of its power under Article 142 of the Constitution. Only for the ends of justice. Supreme Court repeatedly says the High Court cannot do it. There is a reason behind it. I tell you, lordships, why. If this is allowed to be done, first of all, this Article 42 only confined to the Honorable Supreme Court by the Constitution maker, not to the High Court. So there must be some design and object of the Constitution maker that the highest court can do it. If it is to be done by the 24 high courts, different high courts will take different views, and there will be anarchy in justice. Would you lordships get it? There must be rule of law.
Yes.
That's why this power only vested in the Supreme Court by the Constitution, none other else. Then your losses will find. Therefore, my submission, my lord, I do not know how it comes to my learned friend's favor. This is misplaced. It goes against him. Then your lordships kindly see what have been done in this case. This was in regard to certain appointments. Your lordships will find. This was the act, if I'm not wrong. The very first paragraph says, I just tell your lordships, Appointments, Salary and Allowances and Miscellaneous Provisions Act 2012. This was also in regard to. Kindly come to your lordships, last paragraph, what the Supreme Court exercised power under 142, paragraph 44. Having held that the Manipur legislature was not competent to introduce a saving clause in the Repealing Act 2018, what remains to be considered is the fate of the acts, deeds, etc. undertaken by the parliament secretaries who were appointed under the 2012 Act. Clear, your lordships? Supreme Court says even repeal provision bad. But even then, Supreme Court exercises its power under 142. What extent? Kindly see. Nullification of transaction affecting the public due to the acts done by the parliament secretaries appointed under the 2012 Act would cause serious damage to third parties and creates significant confusion and irregularity in the conduct of public business. Therefore, in exercise of powers under Article 142 of the Constitution of India, we consider it necessary to save only those acts and deeds and decisions duly undertaken by the parliamentarian secretaries under the 2012 Act during their tenure. In view of the relief provided, it is not necessary to refer to the de facto doctrine pleaded by Dr. Dhawan.
It is the public business name.
Kindly have a look at this. So Supreme Court says whatever it says, because here every case your lawsuits will find little difference. Here Repealing Act says whatever done, that is saved. Supreme Court says repealing provision is bad in the subsequent act. You can't do having repeal, save this. But ultimately, Supreme declaring Repealing Act is bad, unconstitutional, save this because of they have appointed and served it. But this cannot be done here because they is to serve now if recruited. And with ineligible qualification, they will go on forever.
Yes.
Because Supreme Court says this qualification, and in Devesh Sharma, what they did, Malad Supreme Court, they said within 6 months or whatever time given, you have to do the 6 months bridge course. Without anything, you passed TET. Because Malad, board is to allow, because that was the law. Supreme Court, for this reason, deprecated Rajasthan High Court's Act. Or the, sorry Malad, I should not say Rajasthan High Court, Government Act or Board's Act over there. They did not allow anybody, since that was questioned. But we allowed them, subject to the rider. Now, rider is not, one cannot say that notice was meaningless. One can't say. That is the reason.
Can you just kindly indicate the page number of notice you have shown?
Yes, yes, in the application, your losses will find. Application for, I didn't, I have to give the loose.
No, I'm not loose.
Loose.
Just a loose diyeছি
আমার নীল নইটা কোথায় গেল লিস্ট অফ ডেটসটা চলে গেল দেন Malad, your lordships will get that notification. Just give no, lose আছে তো application unnecessary overburden করেছে. Kaji lordship got that one. Kindly will look at this.
144 of the CAN application.
Exactly. Pending before, subject to final result. Now, Malad, here kindly consider. I will not take the review application. I will just, because your lordship has been placed repeatedly. Kindly see the language. Subject to final result in Devesh Sharma, pending before the Supreme Court. Final result what? B.Ed qualification unconstitutional for primary recruitment. But NCT notification says initially DL, then that was amended by 2018 notification. NCT guidelines eligibility criteria says DLED as per 2010 notification, but subsequently amended. by 2018. So we had to allow it. We didn't do any wrong, but subject to. Then your losses review come up. I'm not taking your losses. I will make only oral submissions because I placed it. Firstly, your lordships will consider who went there, who affected. They went there. Madhya Pradesh High State went there because in the meantime they appointed so many persons. Now the Supreme Court extended to all the state. Only said repeatedly, your lordships will find the language only. Repeatedly, I'm not taking your lordships the paragraph. Your lordships, since your lordships observe certain things, I presume that your lordships are line by line gone in between the lines. Now your lordships will find only those who have derived the benefit of appointment in between. But with the rider, if there is any qualifying order means this type of notice. Kindly consider that, your lordships. Review application, if I take review order, with this qualification, even appointees were not saved. If this sort of notification were there. কোথায় গেল review টা দে? Just a minute. Review order টা. এটাই তো? Just a kindly have a look at this, your lordships. Paragraph 8, I placed it entirely. Just for seconds, your lordships. Of the review order of Devesh Sharma. Has you also got that one? As it appeared, a large number of candidates with BH degree had already been appointed on the basis of eligibility criteria specified by the educational authorities. We do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on August-September 2023 shall have prospective operation. But prospective operation of these judgments shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law to that effect, or that their appointment would be subject to final outcome of this. So this is the our notice, because of the High Court judge order. Somebody moved it. The B.Ed cannot appear in the tape. The Supreme Court judgment was shown just pending. Certain Supreme Courts also passed certain orders.
Yes.
Now, this is the qualification. This notice is a qualification. Though they were not covered by this, they are not appointees either. Now your lordships will find repeatedly, so mere selection of, last paragraph of it, mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. So prospective overruling under Article 142. That's one of the paragraph of the Jairam's Suraj Kumar Okra. This is a 142 order to save somebody. Now I will show, my lord, 142 order cannot derive benefit except those persons who are saved. Clear to your losses. If it is the order or judgment of this is a direction. This is, my lord, judgment means, my lord, least decided. That's the parent judgment of Devesh. This is a certain directions. It directions or, my lord, any direction or order under 142, Article 142, confined to those who are deriving that benefit under the order. Not it can be extended or applied to anybody else. That's I'm showing you. 142. Rafiq Mashi. No, my lord, I am giving you a legible one copy. 2014 8 SCC, page 883. I believe everybody by this time is aware because the Rafiq Mashi judgment, your loss is commonly known as Rafiq Mashi, the future Rafiq Mashi. রাকেশ মাসি দেখিনি একটা মাসি আছে আগে অনেক আগে সেটা 82 সালের পেজটা বোধহয় 883 Namala straightway loss because my submissions confined to 142 judgment is not a precedent. In our view, the law as well as paragraph 8.
Yes.
In our view, the law laid down in Chandi Prasad Unial case no way conflicts with the observations made by this court in the other two cases. In those decisions, directions were issued in exercise of the power of this court under Article 142 of the Constitution. But in the subsequent decision, this court, under Article 136 of the Constitution, in laying down the law, had dismissed the petition of the employee. This court, in a number of cases, had battled with tracing the contours of the provisions in Article 136 and 142 of the Constitution of India. Distinctively, although the words employed under the two aforesaid provisions speak of the powers of this court, and the former vests a plenary jurisdiction in the Supreme Court in the matter of entertaining and hearing of appeals by granting special leave against any judgment or order made by court or tribunal in any cause or matter. The powers are plenary to the extent that they are paramount to the limitations under the specific provisions for appeal contained in the Constitution or other laws. Now, Article 142 of the Constitution, on other hand, is a step ahead of the powers envisaged under Article 136 of the Constitution of India. It is the exercise of jurisdiction to pass such unforeseeable decree or order as is necessary for doing complete justice in any cause of property. Even the Malad to doing complete justice, this power has not been vested. With all humility, I'm saying, Malad, before on the honorable high courts. This is only the power of the honorable. As I placed your lordship, Okram paragraph. I may have missed it, your lordship. That paragraph your lordship will find. Paragraph
33.
33. 33. That's your lordship. As I'm about up to 33. Now your lordship, paragraph 12. Now your lordship, paragraph 12. Article 142 of the Constitution of India is supplementary in nature and cannot supplant the substantive provisions. Though they are not limited by the substantive provisions in the statute, it is a power that gives preference to equity over law. It is a justice-oriented approach as against the strict rigors of law. The direction issued by the court can normally be categorized into one, the nature of molding of relief, and the other as the declaration of law. Pause there for a moment. What Supreme Court says? Declaration of law and molding of power. Devesh Sharma parent judgment, declaration of law, unconstitutional 2018. Now review what? They're molding the relief to an extent to save certain appointees. Now, this is the distinction. Then your lawsuit will find this court in India Bank but such and such has expounded the principle and extolled the power Article 142 of the Constitution of India to new heights by laying down that the directions issued under Article 142 do not constitute a binding precedent, unlike Article 141 of the Constitution of India. Similar direction and review is a direction under Article 142. It's confined to only those. This cannot be stretched to anyone. State with B.Ed qualification has not been saved by the Supreme Court. That's why, Malad, in the subsequent writ petition, they have approached this honorable court, though that is also wrong according to writ doesn't lie to stretch Article 142. But they have for a declaration. Why? They knew because the consequences is judgment. Those petitioners knew the consequences of this. That's why they have approached. Malad, we are the lawyers. We always try to distinguish to save the clients. It's not that's our profession. So, my learned friend can certainly submit that this is a new cause of action when. But ultimately, your eligibility criteria is touched in both the matters. Here you are asking for to appear in the selection process. But you have to clear your eligibility. That's why you have prayed for declaration. You can't do that. And now both the prayers are Malad on that extent. Whatever database, Malad deal that. But if one substantive prayer is equal, that's not Malad, one cannot maintain. Malad, I cited, I didn't go into initially to that extent. I said only that this should be disclosed before your lordship at least. This is the equitable jurisdiction of your lordships today. One must come with clean hands. Look, my lord, I have done it. I have done it, kindly save me. This is one approach. And others, I do not disclose that. I am fighting against this. I am entitled. So, knowing full well that this is the law, this is your act, you do not disclose to the court. Therefore, you are not entitled to any relief. That was initial submission. Now I extend my submission to that extent that having declared, payer for made a declaration, you cannot approach this court again. Now, therefore, these are the things, my lord. My learned friend in Devesh Sharma, my lord, paragraph 88, আমার প্যারাগ্রাফের সঙ্গে মিল ছিল না তখন লাস্ট থিং অফ দেবেশ আচ্ছা ও তাহলে আই এম সরি নাও ইট উইল ট্যালি নাও সরি 88 তো নেই 88 কোন 80 81 ও 80 81 হ্যাঁ নাও kindly look at this. Having made the above determination, we all the same are also of the considered opinion that the state of Rajasthan was clearly error in not calling for application from B.Ed qualified candidates for the reason that till that time when such an advertisement was issued by the Rajasthan government, B.Ed candidates were included as ineligible candidates as per the statutory notification NCT, which was binding on the Rajasthan government till it was declared or unconstitutional by the court, not by this court, by the court. Unconstitutional, an act can be declared unconstitutional by the Honorable High Courts. But what had happened over it? This doesn't help anyone. It was deprecated. The Rajasthan government, why I tell you, lordships. Rajasthan High Court was first disposed of this matter. Our High Court's matter was pending all others. But in between, there is a recruitment process. Rajasthan government did not allow B.Ed qualified. Pause there for a moment. We allowed them to sit for TET with the notification, subject to the rider. Now, Supreme Court deprecate, before you declared it unconstitutional, how can you restrain them? The consequence would have been what, your losses? Had they been allowed and ultimately declaration of unconstitutional, even thereafter review application, they could have got the benefit. Clear to your losses? That they missed that chance. How could you derive the benefit here with this proposition? Because you were allowed to sit with the rider. Look, your fate is dependent upon the Supreme Court judgment. And Supreme Court in review application did not save anyone except interim appointees.
এটা দেবেশ শর্মাতে দেওয়া আছে, এটা টেক নিয়ে
না এটা আমি জানি না এই তো কনফিউজ করিস না জোসেফ unnecessary confusion. ঠিক আছে মালাদ these are মালাদ things your lordships. The other point means মালাদ আচ্ছা ঠিক আছে পড়েন বল না দেখি মালাদ they want my answer in regard
পাল্টা দেখা দেব
দেখি কোথায় গেল ওই জাজমেন্টটা দেওয়ার আগে দেবেশ শর্মা এটাই তো না কোথায় গেল দেবেশ শর্মা
আমি তো নিয়ে গেল তো
Now, what the paragraph 18, what the Rajasthan High Court had stated above is settled legal position. In recent three judgment of this court in such and such, this proposition that a statute which is made by a competent is valid till it is declared unconstitutional by a court of law has been reiterated. I'm supporting this view. I submitted even that, your lordships. But when once declared unconstitutional, it is retrospective. I've shown your lordship in my learned from learned friends. From the statute book it goes. Nowhere, it's nowhere. It's very beautiful, lucid language used in those judgments, your lordships. Sukla Mokra, your lordships will find of the earlier judgments of the Honorable Supreme Court.
33 point.
Paragraph 27. I just, your lordships, repeat that. Where a statute is adjudged to be unconstitutional, it is as if it had never been. My lord, read this, my lord. I request you to read this with this paragraph. Supreme Court says that the government's act was wrong unless Rajasthan High Court declared it unconstitutional. The government could not refuse to allow those candidates. Right. But I didn't do that. I allowed you with the rider. I have given the perfect state. Now, because of the unconstitutionality of your qualification, you cannot derive the benefit of state. That's my point.
Yes.
So this is the paragraph, your losses. Now, your losses. Now, this is the point, your losses. Only one thing. Therefore, my lord, if this point, your lordships, my lord, that's the, my lord, wisdom, and that's the pleasure of the court and pleasure of our profession, your lordships. Your lordships will decide it either way. But if your lordships decide this point in my favor, then next point your lordships need not go into for this matter. But if your lordships is against me, then certainly your lordship has to go to the next point. Now, the next point I tell your lordships, I repeat, my lord, without citing judgment, Shaboni Naik, I explain it to your lordships why I did not cite it. Because, my lord, a slight difference in facts makes the judgment inapplicable. This is settled law. My lord, I am not citing any judgment today. We all are aware of slight difference in facts. My lord, law in both the cases was the same. Prevailing, NCT equal prevailing as on the date of recruitment notification. If I am not wrong, this was the language in the rules. Applies in Saboni matter, applies in this matter. What happened, your lordships? In Saboni's matter, in spite of that's the rule, board ahead one step forward against the rules. Board said pursuing can be considered in the recruitment advertisement. Now, my lord, how this was done, I am not taking your losses. All the debris cannot be cleared by the one debris has been cleared yesterday by the Honorable Division Bench. I don't know how long it will take. I am sorry with the language debris. I know the consequences of the language of debris. This was cleared by the Honorable Division Bench yesterday. I don't know how long it will take by the court. This was done by the board because I can't say your lordship's order, your lordships find in the single judge's order by consent. So, my lord, all that I can say that was not by consent, but written consent. Now, my lord, this was done by the board. My lord, some DLED candidates went before the division bench. My lord, I moved on their behalf. At that point, in that selection matters, I didn't appear for the board. I succeeded. Why succeeded? On the date of advertisement, on the date of publication of the recruitment notification. My lord, that was a division bench judgment presided over by the Honorable Justice Talukdar and Justice Supratim Bhattacharya, if I am not wrong. I, my lord, argued the matter because law is well settled. If the rule says this is the last date, or the rule says on the date of publication, you have to fulfill the qualification, that is the date. If the rule is silent, then advertisement will prevail. If the both are silent, then your losses, it will be presumed the last day of the notification, submission of the application. Now, my lord, put here for a moment, just because I made this as a repetition. Here, my lord, take up the first notice, 25th September 2025. That was the recruitment notification. My learned friend says subsequent. I will deal with that. Now, on that day, none of them, your losses, qualified. My lord, delay, inordinate negligence, that's another aspect. One is recruitment, another is my lord, declaration of the result has nothing to do. Now, my lord, this, suppose your lordships, no dispute. Suppose your lordships, no delay, all these. What would be the law? I'm putting a question to myself. This simply two facts. 25th September 2025 notification, you must have passed with the rule on the date of notification. But according to me, 25th September 2025 would be the date for consideration. Because law says on the date of publication of the recruitment notification. My lord, for the timing, my lord, I said, don't consider the judgment of the Honorable Supreme Court. I will take your losses to that, deal with that. Because each iota of facts makes difference. So, but in that case, my lord, the board says pursuing will be allowed. Now the Supreme Court, my lord, I will not take your losses. My learned friend has taken it. My lord, I am taking your losses. 4 points from the judgment. How that judgment is not applicable. First, your lordship, very clause in the advertisement, Supreme Court said this should be done. This is not there. Second, your lordships, Supreme Court says because of the COVID, course could not be completed even. Forget about the result. Everybody derived benefit for the COVID. From the financial institution, from moratorium, all that. Now, third, fast recruitment notification in the Supreme Court matter was of lordship September. My lord, your lordships, why this judgment cannot be cited or made applicable, I am giving that reasons. First, my lord, there is no provision that pursuing candidates can apply. Neither in the rules nor in the advertisement. Second, my lord, there's a peculiar facts, my lord, COVID, that was taken into consideration. Though, my lord, I'm conscious, my learned friend has shown to your losses that usual practice is that within June, my lord, the results should be published. June course ended. How can be the, my lord, result be declared in June? Your lordships may say me, my lord, say me, Mr. Sanal, this should be within 3 months, 4 months like this. My lord, that's one administrative action. Just because the authority of the same recruitment is a different administrative decision. How can one qualify, my lord, make it, my lord, conjunctive? How? Suppose your lordship authority would have been different. Every year this examination held. This is held in June, result goes November, December, January. Because of the various factors. 1 year election declared, the central parliamentary election. I didn't get it. I didn't get in school. Result, school, these examinations are held in different schools throughout the state. So I have to get it. I have to management it. That is one thing. Second, third, your losses Supreme Court said that some of the candidates was apprehensive they will be overaged. In the writ petition present, your losses will find everybody's age have been disclosed in the bracket. Take any of the pages of the cause study. At least I find they are yet to complete their last date of age, at least 4, 5, 6. Some of them 25, 26. Where is that consideration? Why I'm showing this reason, ultimately I will tell you losses. So age is not a factor over here. Kindly take any one your losses. Page 4, the worst against me, I'll show you. Page 4, petitioner number 15, 34 years. So he will get 6 years more. 16, 35 years. He will 5 years more. I don't know. Farida Parveen probably your losses, OBC B. So he will be 8 years. 3 years exemption they are getting. Everyone, 28, 26, unless he is OBC A, B, scheduled caste, scheduled tribe, 3 years or 5 years more benefit they will be getting. This is your losses. Then third your losses, I am showing to your losses. I am not taking your losses. Saboni's judgment has been passed by Mr. Ahmed. Saboni or Somen, whatever. There are 2 notifications. The first notification was that board is going to invite applications from eligible candidates. That notification did not disclose any vacancies. Now the second notification of sometime in October, that disclosed vacancies. Our division bench judgment, একটা copy yourself ke diye to make the distinction. Our division bench judgment went to the extent simply on the basis of law, because our High Court didn't get 142 power. Look, law is that on the date of publication. Even the court goes into that extent, Justice Division Bench presided over Justice Talukdar. Even if we take the second notification, last date, even then you did not qualify. Then the whole judgment was what? Board notification allowing pursuing also was. Now, what the Supreme Court took a little different view. Since 29 September notification, you did not disclose vacancies. Therefore, it is not a recruitment notification. Clear?
First one.
First one. Now, kindly see our first notification. This disclosed vacancies. If I'm not wrong, 14,000 and all. No. Page 1632 of that. That's the notification. হ্যাঁ হ্যাঁ সব জায়গাতেই আছে আমি যশোরকে এত নোটিফিকেশন 124 your losses will find the very first paragraph inviting applications all that, and if I'm not wrong, in the next page paragraph 9 the date of submission of the application will be disclosed subsequently. That was the second notification. So it's not the same, my lord. Kindly see the Sabonis Nayak's judgment, your lordships, or Shomen Pal. Here, advertisement was not disclosed, and that was the board's affidavit. Sabonis Supreme Court judgment says, my lord, board affidavit extensively quoted. Says, even the board says, that's an intimation that I am going to. So this is not the recruitment notification in substance. That's the affidavit, Sabonis judgment. Sabonis and said that the subsequent notification is the recruitment notification. আচ্ছা আমাকে এর জাজমেন্ট দে শ্রাবণীর জাজমেন্ট দে না সুপ্রিম কোর্টের
ওরা যেটা দিয়েছে সেটার সঙ্গে মিলবে কি
জানি না এটা ওরা বোধহয় দিয়েছে না ওরা রিপোর্টের জাজমেন্ট এটাই দিয়েছে your lordships, if I'm not wrong, that is the distinction point. And Supreme Court relied upon the board's affidavit.
At page 10 and then it continues with 12.
Exactly. Now, my lord, these are the factors, distinguishing factors. Now, your lordships, kindly have a look at the judgment, paragraph 32. My learned friend has given a my lord, online copy of Shomen Pal. Last but one paragraph.
Just I was putting a question before recess with regard to paragraph number 20.
I will just deal with, let me place it, I will deal with. I'm conscious, Malad, that I will place. To some extent, this will be an answer to your lawsuits, but I elaborately deal with that.
Paragraph you are
32.
30. Yes.
Apart from our reasoning that the recruitment notification dated 21st October 2022 is legal and valid also, that is subsequent notification,
yes,
declaring vacancies. We have no hesitation in exercise our power and jurisdiction under Article 142 of the Constitution to do justice. So, because of these features, the Supreme Court exercised its power, distinguishing power on Article 142. Because the Supreme Court in this judgment referred his earlier judgment, Tej, Prakash, all that there are 3 points of law distinguished by the Supreme Court. Because I cited one judgment before this. My personal name with that was dealt with in the judgment. Now, my lord, what? If the law says date of, this is the cutoff date or the date on which you have to fulfill the quality, that will prevail. My lord, I repeat, your lordships, no pursuing clause, nothing, but this was only the date of publication of the notification. Any reasonable and prudent man can presume or my lord, can assess, can determine that the 25th September 2025 will be the my lord, date by which one has to fulfill. My lord, law says if that is not there, advertisement. Advertisement here says in accordance with recruitment rules. So one has to read with recruitment rules. This was my initial submission also. So why should I go to the last date of submission, my lord? Last date of submission, 9th in the second notice, doesn't apply to them at all. Now, your losses pointed out paragraph 20. Paragraph 20.
Yes.
With the 6.2 intendment of Rule 20. Your losses probably on the quoted clause. Kindly look at this. We are in complete agreement with the clear stand taken by the board in its affidavit filed before the division bench of the High Court, in which the board clarified the position as under. Malad, I will hand up your lordships a copy of the division bench. I will not, I am placing it, but I will not take your lordships time. I tell your lordships, board this stand was before the division bench. Division bench deprecated the board, saying you have created this problem. You ought not to have gone against the law. The Supreme Court, to exercise power under Article 142 to sweep those candidates, because pursuing clause, gave this judgment. Now, what is the board's affidavit? Can level look. The aforesaid notification dated 29 July 2021. This is board's affidavit, my lord. Lays down the minimum qualification for a person to be eligible for appointment as a teacher. The notification never stipulates any date of eligibility. In other words, on and from which date such eligibility is to be counted or assessed is not specified in the notification. It can be the first day of January of the year of the recruitment, it can be on the date of recruitment notification, or it can be the date on which the candidate is evaluated. The cost of proxy is stated that no fixed date considered is evident from the aforesaid notification of NCT. Well, this is the interpretation of the board, or construing the board NCT notification. This is absolutely fallacious. Why I tell you, lordships, NCT is not the recruiting authority. One must, my lord, before saying this, one must understand the service jurisprudence. NCT is the authority to lay down the minimum qualification. As soon as it lays down, its functions is over as an academic authority. Now I am the recruiting authority. It's my prerogative, either under the rule or under the advertisement, to say this will be the last date. Unless somebody says and question that date or that notification, that this is arbitrary, well, that will be the value. Clear to your lawsuits? This is the board stand quoted. And 20 lawsuits, kindly see. 21 probably lawsuits also referred to. Having considered the matter in detail, we are of the opinion the High Court committed a mistake in interpreting Rule 26. Rule 6.2 was interpreted in this judgment because of these features. Board on its own give the pursuing candidates an advantage. There was Kabir. There was age apprehension. And that's why 142 power was exercised by the Supreme. Now, kindly, we cannot, before your lordships, we cannot, what should I say, make any submissions contrary to the judgment of the Supreme. Whatever they are there. As a lawyer, I have to accept it. Now, your lordships kindly consider these facts are not here. Then how could they say, but perusing candidate would be allowed or not? Pursuing. That would be the prerogative of the employer. Now, your lordships also said, probably my learned friend has also said, taking the clue from your lordships, you often take it, that how, my lord, in entrance examination, HS. Well, that's the law. Advertisement says it. That's your lordships to pursue education. That was allowed, that's why allowed NCT to pursue education, not recruitment, my lord. Recruitment, I am the competing candidates. I cannot make ineligible eligible. Because of board stand, the board suffered this judgment. And the advertisement, they introduced that, whatever may be the reason. Debris is still to be cleared. There is no pursuing clause. They cannot come up before the court, your lordship, with all humility, I'm saying, introduce pursuing clause. Then your lordship, they are asking your lordships or praying before your lordships to execute, my lord, the or to exercise the administrative power of the administrative authorities by the writ court. How could it be, my lord? It is not apparently arbitrary. Well, it sometimes happens, my lord, in between some advertisement is published. Suppose your lordships, my lord, your lordship has to declare the law. Now, my lord, June is examination closed. My lord, suppose your lordships in the month of September I published the result, but July was the notification. In an hypothetical case, would your lordships do that again? So law, my lord, cannot be declared vacuum in the vacuum declared, or my lord, the proposition of law. What is the arbitrary? Administratively I take time. It's not, my lord, examination like, my lord, any public examination. This is also public examination, like, my lord, academic qualifications. This is a qualification for applying for the teacher recruitment process. There are several things, my lords, to be considered. That's why, my lord, I submitted your lordship 142 judgment, your lordship, article 142. Now my learned friend has taken, my lord, one supplementary affidavit. So দেখি এই যে এটা নাকি my lord, I take your lordships. This person is teacher eligibility test 2022. Then your lordships kindly come to page 5 of that affidavit. পেন্সিলটা কোথায় গেল? Well, this is the application first. I'm taking your lordships. Page 5. Well, first column, personal details. Skip over your lordships, kindly. Academic qualification. Skip over, my lord. Then your lordships, training qualification. 2-year diploma. Passing year 2024. Lordships got that? My lord, what is the qualification I just given, lordships? This DLED and TATE. Now, this is the application he declared TATE, DLED, and then your losses. 6 page 6.
Cancel for. ওই রিপোর্টটা সাবিতা দেখিয়েছিল ওটা
করে ওটা দেখো ওটাও লাগবে
এই সাবিতা যে রিপোর্ট
Now you will also see training qualification, Bachelor of Education. Sir.
Yes.
Is it clear? He has made online application. Online application picks up by the machine. No, I'm not tech savvy. So he fulfills the qualification DLED. It is the form accepted. DLED qualification. Now, what's the case? He passed TATE with BA. Now that I have to consider. I will reject it. Record that. But application doesn't mean that I'm considering him. Or machine automatically takes it. Because he has qualified DA. What's my learned friend case? He is pursuing DLED.
not passed.
Not passed. Had he passed already DLED, his or her application also could have been taken by the machine. But ultimately the board will not. Because we are not accepting it. It's a consistent stand. Because of this application has been taken. Petitioners has gathered it from this person to show that he has taken it. It's not from the board. This is my submissions in regard to this. Now your losses, one report filed by the board has been taken. Yes. Kindly take up this. Kindly, my lord, paragraph 1, kindly will look at the, my lord, I'm just placing it. By the order dated 5th November 2024 passed by such and such, the Honorable Justice Bishwajit Basu directed board to file a report on the said prayer of the petitioners on the next day of hearing. What was the prayer? I will just kindly see. The petitioners are claiming they are also possessing 2 years regular diploma in elementary education from the board and are praying their eligibility to get appointment as primary teachers as may be tested on the basis of their said diploma. Certain dates considered to be relevant pertaining to the claim of the writ petitioners. TET 2022 notification issued by the board, thereby allowing B.Ed trained candidates. 18th October 2022, and this honorable court made it abundantly clear in paragraph 7 thereof that 29th September 2022 notification shall abide by the SLP. This honorable court is and further, my lord. Then your lordship see 7th November 2022, in view of the above order, board was notified. I placed it page probably 144 of the CAN that it will be subject to the final result. Then your lordships, TET 22 result declared. Many candidates who applied with B.Ed did also pass out. 22 result certificates were issued. 11th August 2023, Supreme Court in Devesh Kumar unequivocally held B.Ed is not proper training qualification. Then Silpi Sen matter directed inter alia 5. Says Devesh Sharma has been pronounced by the Honorable Supreme Court. The writ petitioners now seek a direction on the board to disqualify all candidates who participate. By a further decision, all that your losses. My learned friend, your losses, kindly place paragraph 3. Kindly have a look. The candidates pass in TET 22 with B.Ed training qualification may be considered at TET 2020 past candidates since the candidates are already declared as TET 20 past before coming into force of the order of the Honorable Supreme Court of India, such and such. And the Honorable Court in its judgment dated has not specifically stated about the validity of a TET pass candidate with B.Ed training qualification. The board being the examining and recommending authority will verify the eligibility of the candidate being recruited as a primary school teacher at the time of scrutiny and verification under the recruitment process to be notified as and when required. And as per this is the time now. My instruction, we will not allow this. The norms as per the if candidates fulfill the eligibility criteria, then your losses kindly see paragraph 5. The claim of the writ petitioner to alter their training qualification cannot be considered at this stage. What Malad? They applied in 2022 with B.Ed. They said, alter my qualification from B.Ed to DL. Pursuant to TET 20 notification, they filed their application from TET 22 with B.Ed training qualification, which was one of the eligibility criteria at the relevant time to participate. Now your losses 6 is the ultimate paragraph. It is also stated that such a claim is grossly misconceived and not maintainable in law and should be dismissed by the Honorable Court. If on such a claim a mandamus issued, then candidates who participated in TET 22 as B.Ed trained may disturb this court with the petitions on the in perpetuity. And the first eligibility criteria will be rendered and exercised in futility. So this is our stand, that you can't do this. My learned friend saying, I am saying the report that I will allow it. I'm saying it, this is not undone, it can't be done. Well, these are my humble service. But I'm grateful to your losses. I'm taking your losses.
But I shall very briefly add to whatever. Malad, just Malad, yesterday, Malad, I took out from your lordship that the writ petition, but I have made it photocopy and Malad handing over it to your lordship.
Mr. Sanyal, my lord, has exhaustively addressed my lord on the ineligibility of the petitioners, my lord, to be in the selection process for 2 reasons. The one,
that their TET qualification is vitiated. But second, that they being not candidate fulfilling the criteria prescribed, that of training, on the date of issuance of the notification dated 25th September 2025, they do not come within the zone of consideration. Lord, I adopt the submissions of Mr. Sanyal. Lord, I would try, Lord, not to repeat, Lord, whatever Mr. Sanyal has said, save and accept, to the extent as much would be, Lord, required to gain a momentum or a clue to make my submissions. Lord, the sum and substance of the claim of the writ petitioners is that in view of there being a delay in declaration of the results of DLED, they are in a predicament not to participate in the selection process. Had this been declared in time or a little early, or had the recruitment notification been issued a little delayed, then they would otherwise have been within the zone of consideration. Lord, my endeavor would be twofold. First is, even if everything had occurred in time, they would not have been within the zone of consideration because they are not duly qualified TET candidates. Second thing is, I say they cannot make a prayer before the court to mold the rule of the game once the game has commenced.
Yes.
Now, Lord, I would start with Devesh Sharma. Lord, Devesh Sharma related to a sequel to 28th June 2018. Lord, I would say that this is, Lord, the crux of all evils. In as much as the initial prescription of qualification for appointment of teachers as laid down by the competent authority, that is NCTE, did not provide for B.Ed to be a requisite qualification for or an eligible qualification for appointment of primary teachers. Lord, even before Devesh Sharma was decided by the Honorable Supreme Court, Lord, in as many as at least 3 lists were adjudicated by the Honorable Supreme Court on the issue that neither B.Ed is equivalent to DLED or other training qualifications required as an eligibility for appointment of primary teachers. Not the subject syllabus is such that it can be presumed that it is anywhere close to it. Far less to say that B.Ed is a higher qualification. Lord, I am reminded of at least one of the judgments, PM Lata, that was 2003, another Lord judgment which Lord originated from our court, Lord, that was in Dilip Kumar Ghosh, 2005 Supreme Court. Now, notwithstanding this, Lord, on 28 June 2018, Lord, NCTE Lord, issues a notification, Lord, thereby including B.Ed as one of the eligibility criteria, Lord, for taking the TET examinations. But let us understand, Lord, the expanse of this notification. Lord, it had the effect pan-India in respect of all appointments of primary teachers, Lord, which are governed, Lord, by and under, Lord, NCTE guidelines. Lord, notwithstanding 28th June 2018, Lord, insofar as our TET, Rajasthan, Lord, TET examinations is concerned, But B.Ed candidates were not invited. One of them was Devesh Sharma. But he filed the writ petition. But that came to be decided sometimes in November 2021. But in November 2021, the precise date I shall give, my lord.
This was the Honorable Rajasthan High Court.
My lord. 25th November 2021.
Okay. 2021. Yes.
On this 28th June 2018, my lord, was quashed. But understanding the simple effect of this order passed by the Honorable Rajasthan High Court is, Lord, I gain sustenance from the submissions made by Mr. Sanyal referring to Suraj Okram, where the Honorable Supreme Court has said categorically as if it did not exist. So, B.Ed being a qualification, it failed to exist to be an eligibility criteria to take the TET examination on and from the date Rajasthan High Court declared it to be set aside. Now, whether something which does not exist can be taken recourse to and made to be an eligibility criteria by other states, our state set an example. While issuing the notification dated 25th September 2022, it says that the notification has been issued on the basis of, among other, 28th June 2018. I put a question to myself as to whether something which did not exist altogether to be a criteria prescribed by the competent authority, could it be relied upon? If my lord intends to see 25th September 2023, my lord would get that at page 133 of my application.
No, if it says void ab initio,
my lord,
then it goes to the root or the date on which it has been published.
I'm grateful.
Or the date when a competent court declares it unconstitutional. Which date?
I come to that. Now,
because see, from 18 to 21, there might be some candidates. So it gets validity of that. If it is declared as unconstitutional, does it goes back to the date of the publication?
It goes back, it is from the date, of its existence, as if it never existed. The review application, that made the vertical distinction and thereby protected those who got the benefit of B.Ed degree, but in view of the fact that they were already in employment and a process of attaining qualification, taking advantage of the qualification as eligibility criteria, participating in a selection process,
yes,
and getting selected and serving for long tenure. There, the Honorable Supreme Court made the distinction in review application, saying that insofar as these candidates are concerned, this will have only a prospective operation. What was not saved? I need not trouble my lord again by showing the order passed by the Honorable Supreme Court in review. But it said that even those who are in the midst of a selection, they are not saved.
Yes.
Now, My lord, after the Honorable Rajasthan High Court, my lord, quashes 28th June 2018, my lord, it could not have been relied upon, my lord, as an eligibility criteria in respect of any selection under the NCTE guidelines. Hence, my lord, some of those candidates who are genuine bona fide and they fulfill all the criteria of the framework within which, my lord, the selection process should be held. They, my lord, came before this honorable court challenging 25th September 2022. Saying that something which does not exist is being relied upon. B.Ed qualification cannot be an eligibility criteria. The NCT notification has been quashed. Here's our state, which is issuing notification saying that B.Ed would be a qualification. But the Honorable Coordinate Bench said that these selections of the B.Ed candidates shall abide by the result in Devesh Sharma. But I say the first caveat happens in respect of all B.Ed candidates on this day, which is 18th of October 2022. That is, my lord, the judgment delivered by my Lord Justice Aniruddha Rai. Now, taking a coup from here, board issues a notification on the 7th of November 2022. Yet again, putting it to the notice of all, it being the recruiting authority, that those who are taking the process in terms of 25th September 2022, their fate shall abide by the result in Devesh Sharma. But I say that determination of their fate happened on 18th October 2022 when their fate was aligned to Devesh Sharma. This 18th October 2022 was not challenged by anyone. Right? 7th November तक वो challenge करें.
This is of WPA number is?
My lord, yes. My lord would 140. My lord, number is WPA 23202 of 2022. My lord would very kindly get this at page 141 of my CAN 1.
পুরোনো কাগজ দিন তো কাগজ
Yeah.
Next.
Page 141. Not at page 143, I only read 5 lines, the concluding portion, which says, this court makes it clear that all the steps taken and to be taken in terms of the said notification dated September 29, 2022 shall abide by the result of the said pending special leave petition before the Honorable Supreme Court, including the fate of intending candidates who are covered by the said notification dated 28th June 2018. I pause here for a moment to ask a question to myself as to who are the candidates covered by June 28, 2018. It is those candidates who got a special privilege by dint of 28th June 2018, that is the B.Ed candidates. As I said, no appeal was carried from here. And then on the very next page, my lord would find
yes.
At page 144, 7th November 2022, which confirms it is hereby notified that all steps taken and to be taken in terms of notification number so and so dated September 2022 shall abide by the result of SLP number so and so. The B.Ed candidates applying for TET 2022 will be allowed to appear at TET 2022 subject to the final result of the Honorable Supreme Court in Deveshwara. Similar, not that they were not aware, and if the outcome of Devesh Sharma was in favor of Devesh Sharma, means in favor of the B.Ed candidates, there would have been no list before my lords today. They permitted their fate to be aligned with Devesh Sharma. And not only the candidates before my lord, but along with Devesh Sharma, petitions under Article 32 of the Constitution of India were also filed before the Honorable Supreme Court. And all those matters were taken up. Along with Devesh Sharma. What was the prayer of these persons? These persons said that Rajasthan is going to hold a TET examination. Permit us to participate in the selection process. In the process. Now, this is an order passed in writ petition number 355 of 2022. My lord would kindly take up Devesh Sharma for a moment. My lord would find
after the name.
Immediately after the name, my lord would find the list of cases. Kindly see the last but one of the case numbers appearing immediately before the date August 11, 2023. My lord would find 355. Writ petition C number, then my lord would find 137 of 2022, then 355 and 881 of 2022, decided on August 1, 2023, along with Devesh Sharma. My lord has very kindly got it, Lord. I'm grateful. Now, in this writ petition, Lord kindly sees that the interim order, my lord, which was declined, my lord, I have handed up a copy to my lord. In view of judgment delivered by the High Court in a batch of petitions led by the division bench civil writ petition number so and so and pendency of special leave petition led by so and so involving the same subject matter concerning the claim of B.Ed qualification holders to appear in Rajasthan teachers eligibility test. Let notice for final disposal be issued to this writ petition to the respondents. The petitioners have prayed for interim relief for allowing them to submit application forms and to appear in examination. Having regard to the circumstances of the case and the orders previously passed in akin matters, interim relief in terms prayed for is declined. Now, had an interim relief been granted, Lord, it would have operated, Lord, as a stay of the order passed by the Rajasthan High Court, thereby reviving the effect of 28th June 2018. Lord, this, Lord, fortunately, Lord, did not happen. So what was quashed on the 21st of November 2021, my lord, it never got life infused in it any time thereafter again. So 25th September 2022, my lord, could not have been taken, my lord, recourse to, and this honorable court in coordinate bench, as I, my lord, just submitted before my lord, said that in view thereof, the fate of these B.Ed candidates got aligned to Devesh Sharma.
So that's
now, my lord,
in 355 also they were allowed to appear Subject to the final order to be passed.
Yes, 7th November 2022. Now, my lord kindly sees, my lord Devesh Sharma, my lord, has been placed before my lord.
Which paragraph you are referring to?
Lord kindly sees Lord, paragraph 34. Devesh Sharma. In our considered opinion, therefore, NCTE was not justified. My lord,
You are reading from which? This is SCC?
My lord, the net copy, my lord, has been handed over to my lord. একটা net copy দাও না।
No, no, net copy is there.
My lord, kindly do not take the trouble, my lord. I am coming with a SCC copy.
Okay.
এই 34টা কোন প্যারাগ্রাফ? 34 হ্যাঁ এটা in our considered opinion.
It's 63, I suppose. 63, I suppose, in SCC.
I am extremely grateful, madam. এটা দেখো। Yes, I am grateful. In our considered opinion, therefore, NCTE was not justified in including B.Ed as a qualification for appointment to the post of primary school teacher. A qualification it had so far consciously kept out of eligibility requirement. The Rajasthan High Court, by way of impugned judgment, had rightly struck down the notification dated 28th June 2018 on the following grounds. I pause here for a moment. Lord, the correctness of the decision of Rajasthan High Court in arriving at a conclusion that B.Ed is not an eligibility qualification for taking TET examination has been upheld by the Honorable Supreme Court.
Yes.
Now, my lord kindly sees Lord, much emphasis has been laid on paragraphs Lord 80 and 81 by Mr. Ahmed. But I will be failing in my duty if I do not impress upon my lord that the intent of 80 and 81 is correlated to an understanding of existence of a notification and its impact till it exists in the rule book. But the Honorable Supreme Court only found flaw in candidates who were within the zone of consideration in terms of 28th June 2018 not being invited, because until it was quashed by the Rajasthan High Court, B.Ed degree holders were in fact eligible in terms of 28th June 2018. To that extent, the Honorable Supreme Court found that the government was at fault in not inviting the B.Ed candidates till it was 28th June 2018 was quashed. On 25th November 2021. Kindly sees now, paragraph 80 in this perspective. Having made the above determination, we all the same are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for applications from B.Ed qualified candidates for the reason that till that time when such an advertisement was issued by Rajasthan government, B.Ed candidates were included as eligible candidates as per statutory notification of NCTE, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed, we are of the opinion state government could not have ignored the notification while inviting application of even unconstitutional or even any reason illegal. The same had to be stayed or set aside by the competent court before it could be ignored. To that limited extent, my lord, the court found that the government should have invited, because until then, until 25th November 2021, 28th June 2018 was existent.
Yes.
That, my lord, was a view of the Rajasthan High Court. That view, my lord, has been upheld by the Honorable Supreme Court. Kindly cease. What the Rajasthan High Court had stated above is settled legal position. In a recent three-judge judgment of this court in state of Manipur versus Suraj Kumar Okram, this position that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been reiterated. In this perspective, my lord, kindly see, my lord, Suraj Okram paragraph, my lord, 39.2. My lord, once it is declared to be, my lord, unconstitutional, then it dates back, my lord, to the day of its origin, as if it never existed in the rule book. Now, if this is to be, my lord, considered, if this is to be considered to be the valid declaration insofar as the fate of all B.Ed candidates are concerned, then, my lord, all those who were appointed taking B.Ed as one of the eligibility criteria for taking the test examination, they would have also suffered. But the Honorable Supreme Court, while deciding an application for modification filed by the Madhya Pradesh government, my lord, said that what it is saving and how is it saving, and what it is not saving and why is it not saving. But the words used are retrospective operation and prospective operation, and the Honorable Supreme Court very lucidly have ascribed reasons therefore. But what the Honorable Supreme Court has done, Lord, I, at the risk of repetition, say, Lord, is in fact, Lord, an act, Lord, done in magnanimity, an act done in invocation of Article 142. Lord, saving those who are already in service for long tenure of years, when this litigation had not all seen the light of the day. As I said, Lord, they have taken the examination, the eligibility test examination, Lord, they have been successful therein. They have thereafter, Lord, participated in a selection process. They have been able to be, Lord, to gain an employment. Lord, the family is, Lord, surviving on that. Many considerations, including one under Article 21 of the Constitution in India, Lord, it swayed, Lord, the emotions of the Honorable Supreme Court, and the Honorable Supreme Court need not, Lord, assign any reasons when it is invoking 142.
How long? How long?
Lord, Lord, I'll finish.
You have finished or you'll be?
I will finish, Lord. I saw the watch. I say I will finish today.
Lord, only one thing, original side matters. Lordship has kept it at 3:30. Would your Lordship take up the original side matters today?
Amra ki aboriginal?
No, no. Shobai mile that. We are all.
But it depends on how long you will take. Because
Lord,
then I can touch the original side matters.
Lord, kindly, Lord, permit me to continue, Lord, today. I believe, Lord, my learned friend, Lord, would cooperate. Subject to my Lord's kind sanction, if I finish, Lord, it will be in a continuity.
Okay. তাহলে একটু রাখুন।
হ্যাঁ না সেটাই দাদা বুঝছে না everybody should be given an opportunity to earn that is what I request.
Either You'll continue for half an hour or 10 minutes. Then I can touch original side matters. That is the issue.
Milord, what Milord I would.
If you take half an hour, then I have to release the original side matters as of the day.
Milord, in that event, Milord, I try to conclude by Milord within 20 minutes, and then Milord possibly original side matters Milord can
10
be
minutes,
touched.
nothing will happen.
Okay, then original side touch bad din. आज का original side matters level.
Very well.
Yeah.
My lordship takes it some other day.
Uh,
But
Original side item number 1, my lord, we mentioned it for
Yes, yes, I know.
May
Switch
it
it.
retain its position, my lord.
Yes,
next
yes, it
week.
will retain.
Item number 1.
11th so for reviewed. Preview with there.
some other day, my lord, tomorrow or any other day when it's convenient to the
Not tomorrow. Thursday, I'm taking up original side matters. Thursday will take.
Very well, my lord.
Yes, yes, sir.
Great.
Yes, sir. No mentioning right now. I'm hearing a matter. Original matter next week. Yes.
Now, Milord, kindly, Milord, see that the Honorable Supreme Court, Milord, tried to save the devastating effect of Devesh Sharma in the review by saying that insofar as those candidates who have reaped the benefit of having B.Ed qualification and gained employment after having that eligibility test of test, they would not be disturbed. For them, Milord, it will have only, Milord, a prospective operation. In respect of all others, Milord, kindly permit me to, Milord, to place, Milord, the 4 lines which make the difference in understanding the import of Devesh Sharma, Milord, in review.
Yes.
Milord, kindly sees, Milord, internal page 8 of the judgment. Milord, kindly skip over, Milord, the first 5 lines and kindly, Milord, see the line starting with the words services of only such candidates. My lord has very kindly got it, Milord.
Yes.
Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment, from the date our judgment was delivered on 11th August 23. Mere selection of such candidate or their participation in the process will not entitle them for a benefit under our present order. Lord, I pause here for a moment. Now, what my learned friends, clients, Lord, are seeking is to permit them to participate, notwithstanding the fact that they have gained, Milord, the TET qualification relying on a B.Ed degree. The Honorable Supreme Court, Milord, made it clear that even in respect of a recruitment process, if they have been selected or have participated in the process, they will not get the benefit. But this takes me to, Milord, the philosophy behind invocation of Article 142, Milord, to do complete justice to the person in front of the court and the persons, Milord, who are dependent on him. So it was a question of, Milord, saving the livelihood of a person on whom there is a family, Milord, which depends. That, Milord, possibly where the considerations, Milord, we swayed the Honorable Supreme Court, and thereby, Milord, the Honorable Supreme Court made that, Milord, vertical division in classifying as to who can get the benefit and who would be governed by this. Milord, it was, Milord, a sharp sword, it cut hard. The Honorable Supreme Court, Milord, extended its mercy only to a particular category of persons, only to a particular class of persons, which did not include, Milord, I lay emphasis on the word, did not include any person who was selected or was undergoing a process of selection.
Yes.
Now, my lord, kindly sees if today, my lord is being asked to exercise, my lord, a power identical to the one exercised in review petition by the Honorable Supreme Court, whether such a prayer can be made before my lord. I am praying for an identical relaxation that I be also permitted to participate. Save me from the wrath of Devesh Sharma's devastate. Lord, whether this can be prayed before my lord. Lord, the answer lies in this decision reported in AIR 1992 Supreme Court, page 1593. Lord, kindly sees, Lord, hey, ask, please. But kindly sees the last 10 lines, Lord, starting with the words, it is therefore not proper. Lord, on the first page itself. It is therefore not proper to suggest that if the Supreme Court has issued an order in the circumstances, the similar order can also be issued by the High Court. There is still another reason why the High Court cannot be equated with the Supreme Court. The Constitution has, by Article 142, empowered the Supreme Court to make such orders as may be necessary for doing complete justice in any case or matter pending before it, which authority the High Court does not enjoy. The jurisdiction of High Court, while dealing with the writ jurisdiction, is circumscribed by limitations discussed and declared by the judicial decisions, and it cannot transgress the limit on the basis of whims or subjective sense of justice varying from judge to judge. It is true that the High Court is entitled to exercise its judicial discretion in deciding writ petitions or civil division applications, but this discretion has to be confined in declining to entertain petitions and refusing to grant relief asked for by the petitioners on adequate considerations, and it does not permit the High Court to grant relief on such a consideration alone. Therefore, the High Court was not entitled to pass any order which it thought fit in the interest of justice. Lord, kindly sees, Lord, what is the prayer of the writ petitioners. Admitted position is that I am not eligible in terms of the advertisement. Now, what is the advertisement? Lord, kindly sees for a moment. Lord, 25th September 2025. Lord, my lord would very kindly find that at page 160 of my application.
Yes.
Lord, kindly sees, Lord, 25th September 2025. Lord, kindly sees, this is, Lord, in terms of the West Bengal Primary School Teachers Recruitment Rules 2016, and kindly sees the qualification required. My lord would see 3B, the candidate must have passed. Lord, I lay emphasis on all the three words, must, have, and passed. Lord, after having inserted this in the advertisement, which is in consonance with 2016 rules, Lord, I put a question to myself. Can an interpretation be given that this includes within its periphery those who are still pursuing and do not possess the requisite qualification? Their results are yet to be declared for whatever reason, and whosoever is to be blamed. Your zone of consideration, as we have learned in service jurisprudence, is like a room where you have to show, you have to wear your qualification on your chest. If you can show it on your chest that you have the qualification, you are entered, you are permitted to enter inside the room, or else you are outside it. So as on the date, my lord, when this notification is issued, I put a question to myself whether, my lord, these candidates who say that they are pursuing DLED, they, my lord, they qualify on the anvil of must have passed. My lord, the answer, my lord, is, my lord, a no. And then, my lord, kindly sees, and my lord would find all or, and then and teacher eligibility test conducted by the West Bengal Board of Primary Education adhering to the rules and principles set by NCTE. I say that these B.Ed candidates, Lord, they did not take the TET examination adhering to the NCTE guidelines, and that they were not doing so, Lord, the court put them at caveat and aligned their fate to Devesh Sharma. The board, Lord, put them on notice on 7th November 2022. And after Devesh Sharma is allowed, and the review which says that it does not save any other persons than the appointed persons, I say, Lord, they do not, Lord, qualify on the anvil of this and do not come, Lord, to be the eligible candidates within the zone of 25th September 2025.
না না আমি বলছি রিক্রুটমেন্টের ক্ষেত্রে হ্যাঁ বলছি সেটা বলবো হ্যাঁ এটা রিল্যাক্সেশন সেন্টার চাই
Yes.
Now, Lord, that would take us to Lord Showman Pal. Lord, I took an exception when Mr. Sanyal said that I argued in Shabuni Nayak, I argued, Lord, we all the learned Lord, juniors who assisted him, Lord, we were not referred to at all. And Lord, that I am speaking, my Lord, with this fluency before my Lord today. It's all because, my Lord, my learned friends on my right side, my Lord, they helped me with by toiling the night oil, my Lord, that I am able, my Lord, with their assistance to speak before my Lord. Lord, in Shabuni Nayak, my Lord kindly sees, which was taken up, my Lord, before the Honorable Supreme Court, my Lord would see that cause title would run with the name of Showman Paul.
Yes.
Lord, my Lord, may kindly not, my Lord, take the judgment. There, my Lord, the feature in distinction are that a relaxation was granted there, my Lord, in respect of candidates who were pursuing. Lord, no such relaxation, my Lord, would find in 25th September 2025. So, if that be so, then what the petitioners are asking before my Lord today is to bend the rule.
At this election.
To bend the rule. Now, whether, my Lord, I say, a writ of mandamus, my Lord, can be asked to be issued in violation of rules, or to read the rules in a manner that it does violence to the rules. Lord, kindly sees, Lord, in identical situation where a prayer was made in respect of TET examination, Lord, in the state of Jharkhand, please. This is, Lord, 2025, volume 1, Supreme Court reports, page 1953. Lord, before, my Lord, I take myself, my Lord, to the judgment. Lord, this was a case where Lord, insofar as candidates who have taken CTET and, Lord, the TET examinations of neighboring states, they were also permitted to participate in the selection process by dint of an admission made by the learned Advocate General in course of the proceedings before the Honorable High Court. That very well we shall permit them. Lord, the highest law officer of the state, gives an assurance to the court, is an assurance on behalf of the state. So state is agreeing to bend the rule of permitting the candidates who have passed CTET and who have passed the TET examinations of neighboring states, whereas, my lord, insofar as the recruitment conditions, my lord, or rules are concerned, they did not, my lord, permit any other candidate but those who have qualified the JTET, Jharkhand TET, my lord, to be only eligible. But this was the background in which, my lord, the list fell before the Honorable Supreme Court. My lord, kindly see how the Honorable Supreme Court deprecated, my lord, bending of rules and said that once you have declared by an advertisement what are the eligibility conditions, my lord, the eligibility criterion will have to be determined on the date the selection process commences. And what is the date of commencement of selection process? The Honorable Supreme Court in paragraph 32 says it's the date on which the advertisement is issued. My lord, kindly, my lord, sees, my lord, paragraph 3 and 4, my lord, lay down, my lord, the brief facts of the case. My lord would very kindly get that at page 1958.
Yes.
The instant appeals arise out of judgment dated so-and-so of the Honorable Jharkhand at Ranchi, permitting the private respondents who were residents of Jharkhand and cleared the CTET or neighboring states STET to participate in the recruitment process for the post of assistant teachers in primary and upper primary in the state of Jharkhand in furtherance to advertisement number so-and-so. Applicants have cleared the Jharkhand so-and-so test and are challenging the participation of private respondents. Now, my lord, the appellants in this case, my lord, are akin to, my lord, the added respondents, my lord, whom I represent before my lord. Lord, kindly sees, in the present case, the dispute arose when the private respondents herein seated qualified candidates filed writ petition and other petitions being so-and-so before the High Court, Jharkhand and Ranchi, seeking direction against the state to either conduct JTET or permit seated qualified candidates to participate in the recruitment process for the post of assistant teacher. It was contended by the private respondents herein that the state of Jharkhand conducted the last JTET in the year 2016 and since then failed to conduct JTET. This has caused irreparable loss to thousands of eligible aspirants who have been waiting for recruitment as teachers in Jharkhand but have not been permitted to participate as they do not possess JTET qualification. Before discussing the merits of the case, it would be apposite to discuss the factual background. I pause here for a moment. So, my lord, what was, my lord, what was the alibi, my lord, given by these candidates to invoke the sympathy of the court? That JTET examination has not been held for long. We have qualified CTET, we have qualified STET, so kindly permit us, bend the rule for us in view of these administrative defaults. Now, in respect of the petitioners, my lord, I draw an analogy and say, why are they before my lord? Because they indicate to my lord that there is an administrative default, what? The results have not been declared in time. Now, although, my lord, the authority may be same, but the administrative functions, my lord, are different, and my lord, it cannot be seen to be, my lord, the same side, the two sides of the same coin. But my lord may haul up the authority for not taking examination in time, not declaring the results in time, but that, my lord, would not inure any benefit, my lord, by default in favor of the petitioners. That very well, since you are the victims of this delay, so the court is permitting you to participate. That, my lord, I would say would be a misplaced sympathy, resulting in bending the rule of the game once the game, my lord, has commenced.
Yes.
Number kindly sees, my lord, under the RTE Act, my lord, NCTE has been recognized, my lord, as a academic authority. My lord, it has, my lord, the power, my lord, to frame, my lord, the eligibility criterion. My lord, the Act, my lord, also empowers the central government to provide any relaxation in appropriate cases. My lord, now, if I Lord, understand section 23 of the RTE Act, Lord, in a holistic manner, I understand that NCTE fixes the guideline. However, central government reserves its rights to make any relaxation thereto. But I put a question to myself as to whether any discretion is left to any other authority to invoke any power for causing any amendment or relaxation to the rules or the prescriptions made in the statute or in the eligibility criteria. But the answer to that, my lord, would be no. So if the rules say, Rule 6.2, my lord, kindly permit me to recollect. My lord, Rule 6.2 says must possess. My lord, the advertisement says must have pass. And on this day, my lord, the rights of the parties, they crystallize. All those aspirants, I say, when on 25th September 2022, 2025, this advertisement was published, Mr. Ahmad's client, my clients, and like many others, my lord, who are vying for a piece of bread, my lord, and a pound of butter, they are all aspirants. Their rights crystallized. Now we all have to do introspection as to within the four corners of this advertisement, we qualify to participate or not. Now, there is a distinction between being an aspirant and being a candidate. I may aspire, but I don't fulfill the criteria. I can't become a candidate. With deepest of respect, my lord, I say that Mr. Ahmed's client, they remain to be an aspirant. They don't qualify to be a candidate. Why? My lord, the answer, my lord, can be found in paragraph 32 of the report. Thus, the date of, my lord has very kindly got it. Thus, the date of issuance of advertisement would be the date of commencement of the recruitment process, and the minimum qualification and eligibility prescribed for an assistant teacher was to pass the JTET conducted by the government of Jharkhand along with other educational qualifications as specified in the advertisement number so and so. As such, it can be safely concluded that on the date of commencement of the recruitment process, the qualification as prescribed by intermediate or graduation with JTET for candidates applying in furtherance to the advertisement for the post of assistant teacher. Lord, over. Huh? Lord, kindly sees Lord paragraph 52. Lord, this refers to a constitution bench judgment, Lord, rendered in Tej Prakash's case. In the sequel of facts and discussions made herein above, and to elucidate the issue legally in detail, we can profitably refer to recent judgment of the Constitution Bench of this court in Tej Prakash Pathak, so and so, whereby this court had the occasion to deal with the question as to whether the state can tinker with the rules of the game insofar as the prescriptions of eligibility criteria midway. While answering the said question in clear terms, it was held that the eligibility criteria, essential qualification of candidates seeking recruitment, cannot be altered after the recruitment process has begun. Konta? Kano?
Relaxation power যেটা আমি বলে
পড়ে যাচ্ছে. Then, my lord, the cutoff date with reference to which the eligibility has to be determined is a date appointed by the relevant service rules. Then, where no such cutoff date is provided in the rules, then it will be the date appointed in the advertisement inviting application. And if there is no such date appointed, then eligibility criteria shall be applied by reference to the last date appointed by which the applications were to be received. Now we take, my lord, either of these dates. We take either of these criteria, either the rules or the date of application, they don't qualify. There has to be a cutoff date. Now, kindly sees paragraph 53. The Constitution Bench has also clarified that the recruitment process commences from the date of issuance of the advertisement and concludes with filling up of notified vacancies. Then, my lord, the court, my lord, I don't read, it has been placed before my lord. And then paragraph 54, after much deliberation, the Constitution Bench concluded the reference as followed. My lord, kindly skips over one. Kindly will see one. Recruitment process commences from the issuance of the advertisement calling for the applications and ends with filling up of the vacancies. Then 2 is important. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process.
Yes.
Unless the extant rules so permit. It is nobody's case that the 2016 rules will not permit any such relaxation. Or the advertisement. There is no relaxation provided because I have indicated that the nota bene also provides that those who have undertaken the TET examination in adherence to the NCTE guidelines only. So by default, all others are excluded. So there is no relaxation even permitted under the advertisement. Paragraph 55, the position of law as per Tej Prakash is therefore clear that the recruitment process commences from the issuance of the advertisement and that eligibility criteria as laid down therein cannot be changed midway during the recruitment process unless the extant rules or advertisement permit such a change after issuance. Even if such power to amend is reserved in the advertisement or rules, it must be tested on the anvil of Article 14 and pass the test of reasonable. Lord, kindly sees, Lord, notwithstanding this, if a prayer, Lord, comes before my Lord, Lord, whether my Lord, would entertain it, Lord, to be one in the periphery of the rules, Lord, which govern this recruitment process. Lord, my Lord would kindly see, Lord, paragraph 25 and 26 of this judgment, my Lord. It has the answer. The case as, I'm sorry.
Yes. Yes, sir.
Paragraph 25. The case as set up is that the state government, by providing relaxation and allowing seated and estate holders to participate in the ongoing recruitment process under the advertisement, has usurped the powers of relaxation vested only in the central government under Section 23(2) of RTE Act. In the case the state lacks adequate institutions for imparting training to teachers, or there is dearth of sufficient teachers possessing minimum qualification, then the central government by notification relax the minimum qualification of the teachers. The state government does not possess power to relax qualifications for appointment except in the manner prescribed by the NCTE guidelines. So, Lord, as I submitted, Lord, it is not.
Yes.
It is not that, Lord, there is an absolute power, Lord, vested in the authority to, Lord, to tinker with the rules. It is only, Lord, that the notified authority, Lord, can relax the rules. And when can it relax? Lord, it is, Lord, also, Lord, provided for, Lord, in the NCTE guidelines, which is, Lord, referred to and relied upon in paragraph 25. So the state or any other functionaries, Lord, least to say about the board, not being competent to, Lord, permit persons who are ineligible to participate in the selection process. Lord, that cannot and does not arise. Neither the rules nor the advertisement will not permit, Lord, ineligible candidates, Lord, to participate and to pray before my Lord, Lord, that despite being the fact that we are ineligible, it is an admission. We should be permitted in view of some administrative default somewhere. my lord, I say that the writ petition, my lord, is liable to be dismissed.
Interim order passed by the coordinate.
And my lord, I would be failing in my duty, my lord, if I do not indicate to my lord that, my lord, the applicants before my lord, they have, my lord, sought for, my lord, cancellation of the TET certificate of all those candidates who took the TET 2022 examination relying on their B.Ed qualification, and therein, my lord, an interim order, my lord, has been passed. That interim order has been made absolute, my lord, till the disposal of the writ petition, and my lord, it appears, my lord, at page 153 of, my lord, my CAN application.
153. Read number.
WPA 2661 of 2024.
It has been made absolute till the disposal of the writ petition.
Yes, till, my lord, that is, my lord, that extension is at page 156. Six.
159 already.
The relevant ordering portion is at page 159.
Yes.
So, my lord, with open eyes, my lord, they participated. My lord, today, my lord, they cannot, my lord, turn around and say that Devesh Sharma has not hit us.
I thought there is no reply of reply. But since my learned friend has pointed out two different things which I could not address. The Shilpi shot, that Shilpi Sen's judgment, Mr. Shanal appeared for the writ petitioner, where that was for the recruitment in the with B.Ed qualification. We are not seeking for appointment with B.Ed qualification. It is also DLE. And another, which I missed, is that the Honorable Supreme Court, considering Devesh Sharma's judgment, allowed some candidates to party interim protection has been given and directed to appear in the selection process. So that I missed. And I also missed one very important feature, is waiver section 6 of the General Process Act. Everybody is disjunctively reading piecemeal the observations, but nobody is reading paragraph 80 and 80 together.
No, I read 80 and 81 together, and I addressed
the answer.
No clarification is B.Ed and the beach course. They don't have the beach course.
একটা লাইন পড়লে হবে না চিত্ত তার আগে
First line says applicants are primary. It is a private school. They are not private school.
There are private school. That is the reason bridge course. It says
they are not teachers.
They are private school teachers, so that was the reason bridge course. 6 months bridge course. 2010 notification was.
In service candidate. Yes,
in a private school. In service
in a private service candidate. This is
আরে ভাই উফ যশা বসে আছে তোরা নিজেদেরকে অ্যাড্রেস করছিস কি মুশকিল
in service. They are not a fresh candidate.
Since the matter is pending, so interim measures that was.
Lord, only one line, my lord, I must say. Lord, that order, judgment which is handed up to my lord.
Not judgment, it's an interim order.
I am so sorry. I'm sorry. No, please. I stand corrected. Lord, kindly sees, my lord, who are the applicants before the Honorable Supreme Court. Lord, kindly sees the second internal page of the order. Kindly see the applicants petitioners are primary teachers in private schools having qualification of B.Ed and bridge course.
They are covered.
It's very difficult if everyone starts completing my sentence. Then you better complete it. I start my own sentence afresh. This, my lord, is covered by the order passed by the Honorable Supreme Court in review petition, where the in-service candidates, my lord, were protected. Those who have reaped the benefit. Now, these candidates may be in private school. They are rendering service with which clause, whatever, I do not know. I say the sum and substance is, if you have reaped the benefit, you are in service, then the bread and butter is in question. Lord, 142 was invoked for that purpose only. That vertical division was done with that objective. I am extremely grateful, my lord. I could not have expected a more patient hearing, my lord, on this matter from any other.
But the
Thank you,
important
sir.
is, however, that not perhaps, I was just relying
Uh,
on this. However, the apprehension of the applicant is that their application may not be considered in the light of the order passed in Court of Devashko. That was the reason I have referred
Very-
that the apprehension still.
Or Mr. Sabir Ahmed, learned advocate for the petitioner, who concludes his argument. Mr. Subir Sannar, learned advocate appearing for the board, also concludes his argument. Argument is also concluded on behalf of the added respond numbers 10 to 15 by Mr. Piyush Chaturvedi. 84 orders. Eighth did please this matter 8 for orders. Okay,
Grateful
thank
to
you.
my
Blessed. Deeply blessed.
Thank you. বলুন এগুলো ভালো করে বেঁধে সব একসাথে রেখে আমাকে চেম্বারে পাঠাবে, ঠিক আছে?
আমার সঙ্গে খাচ্ছে ওর নাম
ওগুলো সব একসাথে রাখো। ঠিক আছে, থ্যাংক ইউ স্যার।